this out, I want everybody to go over there and bomb Eli's channel. You see the knife up. I'm going to end the stream. It's going to have like a minute video at the end. And then, because he's got about 30 seconds before his stream starts anyways in the very beginning. So everybody, I want you guys to go over there and let him know that I told that BZ Watchdog told everybody to come over and bomb his channel, do a BZ Watchdog raid like Chuck Bronson does.
Oh yeah.
So go over and raid his channel. I'm gonna close that out.
Yeah, you do that.
Appreciate you coming on, Brick. Help me out there with the promo and with all you guys. Appreciate all your help. Chevy, April Rain. With that being said, I'm going to end the stream. Watch the promo at the end, guys.
Don't forget to watch that promo at the end, guys.
Another great product brought to you by TAP Security Products. Streetwise Security Products has manufactured another fine product brought to you by TAP Security Products. This is the Falcon 5-inch spring-assisted Second Amendment knife. It's got a 3-inch handle with a 2-inch blade that has the Second Amendment of the Bill of Rights etched and engraved into the blade, as you can see here. It also has a seatbelt cutter along with a glass breaker at the very end of this knife, along with a beautiful American flag handle.
Looks pretty cool.
The Second Amendment knife retails for $19.99. Right now, you can buy it through till the end of Christmas online at tapsecurityproducts.com for a low special price of $14.95 plus tax and shipping. Again, that's tapsecurityproducts.com. Get your products and stocking stockers now.
Yeah, that's not a bad price, BZ. I knew right away it was a BZ Watchdog blade. As soon as you mentioned it was 2 inches. So how's it going, guys? Really good seeing you. So tonight we're gonna have some fun. What's up? What's the matter, you? What's the matter, you? Hey, gotta know respect. Hey, what do you think you do? Why you looking so sad? It's not so bad. What's up, BZ? Hey, good seeing you guys, man. Yeah, oh man, I know I got hell coming my way after that little intro. Just having some fun, guys. All right. Yeah, and so Integrity Now news, we'll cover it. So, guys, last night I was hanging out with Brick and Let's OTVO and all the dudes over at BZ Watchdog's channel. I was trying to get some work done. And as usual, because we're all alpha personalities, got into a big debate, which is cool, you know. And bring assisted when closed. Yeah, that's right. Let's OTVO. So anyways, during that conversation, they told me about this dude saying this dude was able somehow to record in court, and he bested the judge and he bested the attorney. And of course, now I see that I come to find out that the attorney is a law professor. So right away, I'm thinking this is somebody who probably does not really practice law. Now, most of the time, you'll find those who can do and those who can't teach. In rare occasions, you'll get somebody like me who has done for a long time, and I feel obligated to try and share what I learned with people because I care about people. And so I'm sharing stuff with you that's outside the type of law that I've really been practicing for the last many years, because it's stuff that I think would help people who are having their rights violated, because I believe in government accountability above all else. Now, for those of you who don't know me, my name is Michael Eli. I am a California and Texas licensed attorney. I do personal injury law primarily, like police shootings, tight handcuff cases, but more so motorcycle accident cases and car accident cases involving military vets. My primary clients are military veterans because I am an inactive U.S. Marine. I was disabled from the Marine Corps and got medically boarded out under honorable conditions, but I've stayed active in the Marine Corps community, helping EAS Marines who are getting out at the Wounded Warriors Battalion over at Camp Pendleton and trying to help them find jobs, trying to teach them how to become lawyers on the law study program, which is how I did it. I became a lawyer with no undergrad or law degree on the California State Bar Law Office study program. And I also wrote a book about how I became a lawyer with with no law degree or undergrad, to try to motivate a lot of you people who I think have talent, but lack some of the other skills that you're going to need to be successful as lawyers. And yes, I'm not a member of this British accreditation registry or whatever you guys want to call it. A lot of the sovereign citizen movement people, they don't really know what they're talking about, but that's cool. I still support you guys, and I want to teach you guys how to win in court if you're going to go in there pro per. And me becoming a lawyer with no undergrad or law degree has enabled me to help a lot of my friends who are sovereign citizens get out of jail and teach them how to handle themselves in court, because that's super, super important, guys. If you're going to go in there pro per, you should know how to handle yourself, and you should know how to best judges and the other side, not by being a jerk. And I'm just going to keep telling you guys this. You get more with sugar than with salt, and you'll win over the judges, the courtroom staff, and everyone else and blow their minds if you're able to handle it with civility. And so we'll talk about that as well. But that's right. That's right, Bo Ghibli. I believe that too. The best teacher is the one who has done, and they can share their knowledge. Chevy. Thank you, Chevy. By the way, guys, Chevy is like one of the biggest supporters of my channel. And Chevy, I'm always humbled by you because I don't know who you are, but I assume that you like Chevys. And I used to build Chevys with my dad in the garage when he was still alive. And you're one of the main reasons why my wife doesn't sweat me so hard when I do these shows, because to be honest, we homeschool our kids, and she would rather me be teaching the kids and taking my son to judo class. But I'm like, look, this gives me a sense of purpose besides just making money in the daily grind of dealing with pissed off clients who call me every 5 minutes complaining about something or another. So it's a good way for me to get back into where I come from, which is the pro per litigant movement. I mean, that's how I got my start, fighting traffic tickets, recording police back when they used to beat you up and throw you in jail. And that's what inspired me to become a lawyer. Is I got beat up by a West Covina cop because I was demanding a copy of his identification. And that's before we had camera phones. Lucky for me, I had my Marine Corps brothers who lived right down the street, who came and immediately got witness statements. I called them from the jail, and immediately within seconds, they were at the Bally's Total Fitness that I managed as a corporate wellness director, where I was loading my truck, getting ready to go out and do a mall show at the mall down the street. And it's another reason why I've always taught, stay part of an elite unit. And the Marine Corps is a great one because we're a brotherhood, and you're always in. You join the Army, you join the Air Force, you join the Navy, you join the Coast Guard, but you become a United States Marine, and it never leaves you. And that's something these morons like Dick Bag will never understand, is that it becomes who you are as a person. And it's served me well, and it's been a really great thing for me. So let me see here. Chevy is a psychoanalytic genius. I don't know, but I think he's really a cool dude. And he's always supported my channel and made it possible for me to bring you these shows. So please make sure to like and subscribe to Chevy's channel and give him some motivation. And Anton, anybody can consult with me, but just keep in mind, guys, I am not interested in doing any kind of civil rights cases unless it involves like a police shooting or a tight handcuff type case where you've got an amputation, because the amount of money that it costs to bring one of these cases is astronomical when it comes to bringing a federal civil rights case compared to what you could potentially recover. And unfortunately, most of the cop watcher auditor community have personal crusades that they're on, and they want to take charge and run the prosecution of their claims. And that's not how I roll. I'm not gonna be somebody's bitch and let you tell me how to litigate a case. However, I'll still be your friend and try to help you in any way, shape, or form that I can. But I'm not going to sit there and get in a battle with some dimwit who thinks they know more than me when I practiced law for 20 years and already been jailed and beaten up by cops, and I know how to deal with the system. So if you think you know more than me and you think you're smart, then great, then do it yourself. But I'll do my best to try to help you so you can learn and get better at it. And the one thing that I really want you to take away from this show tonight is civility, because that's something that is seriously missing from from this particular show that we're going to do tonight. Damn it, I was shrunk down there for a minute. So I'm in a good mood today, guys. I made it to the gym. I train at Powerhouse. Normally, you guys will see me at like 5 a.m. doing my hasty workouts, but I actually got to do a real workout today at the gym, so I'm feeling good. I got to do shoulders and arms, which I really needed to do. But man, I am really out of shape. But doing this law thing is a grind. Sitting in front of a computer all day working is a grind. It really tears you up. So all you lawyers out there, you disgusting fat bodies, get your butts to the gym. There's no excuse. Even if you can't get to the gym every day, do a hasty workout like I do. I've got videos that are on my live section where you can see like a little bit of the workout that I do. I incorporate some of my judo katagamis into my workouts because I like being able to maintain explosive torque, especially as I age, just because it makes me feel young. Like I can still throw people like, rag dolls that are like twice my size. And so I try to maintain that. Makes me feel motivated and super, super strong. And you're right, Rich. Like for me, it is mostly water weight, by the way. And you can lose about 10 pounds a month just by doing a high protein and vegetable diet. And that's the way I get shredded. But because of Thanksgiving, man, I just porked out and did all the wrong stuff. So forgive me, guys, if my face looks a little pudgy, but I'm going to work on it and try to get leaned out for you guys. So in the video today, what we're going to talk about is this dude, Lane. Hold on a minute. His name is Lane Meyers, and he's out in Arizona, and he's a pro per litigant. And so at the outset, I want to say, look, I got nothing bad to say about the guy. He's not a lawyer. And a lot of the stuff that he did, was, I think substantively, he was right on a lot of the substantive law. I just take exception to the courtroom drama and some other things that we're going to get into. And we're going to talk about that. And we're going to talk about a lot of the things that he was wrong about too, because I want to help him get better. So Lane, if you're watching, this isn't in any way, shape, or form. I'm not one of these frauditor guys who tries to like pick people apart and put them down. I believe in God, and I believe that we should all be building each other up and trying to, because we should all be brothers in Christ as far as I'm concerned. And we should be trying to build each other up, and like iron sharpening iron, we should be trying to help each other. And give me a bunch of ones in the sidebar if you guys agree. For all you atheists, I'm still cool that you're here, because at least I know that I can be an influence on you to help you see that there are good people out there who won't judge you and believe in natural law and want to make the world a better place for your kids. So that's something that we should definitely get into tonight as well. And look, I know a lot of you guys don't believe in God or whatever, but if you believe in natural law, then you do believe in a creator. And that's a good start, because all of our rights come from an all-powerful creator, not from the government. And as soon as you agree with the left that your rights come from the government, that means that you agree you have no rights, because the government can take them away at whim. And so my job here today is to, well, number one, cover this cool video, because there's a lot of really good things we can learn from it. And then I'm going to tone it down a little bit about talking about humiliating people. And, because that's not what you want to do. You don't want to humiliate people, guys. What you want to do is you want to build each other up. And if they're your enemy, you kill them with love and kindness. And I know it's hard, but we're going to get into that as well. Hey, what's up, Delete Laws? Hey, guys, Chili's here. By the way, give me a bunch of ones for Chili de Castro so let's score 3 for Chili so far, right? He got the one case dismissed on appeal. He got the other one thrown out, and he just got his channel back after all these scumbags, the so-called frauditor guys, were trashing him, spreading defamatory lies about him, trying to paint him in a false light, like somehow he or me or Brian or somebody like messed it with his channel, which is, of course, you guys, if you have any sort of discernment, you would know we would never do something so stupid as that. And give him a bunch of ones, guys, for Chili always coming back like Rocky, just constantly, man, Rocky's got nothing on Chili de Castro. I mean, he's just killing it. So super happy that Chili stopped by. So tonight, hey, Shock Prof, good seeing you, man. And hopefully, Shock Prof, you got my comms. And well, BZ, we can talk about that in another episode too. And all I can tell you, I'm also a philosopher of different of different cultures. And there's an ancient Chinese saying, BZ, that says, for every door that closes, another one opens. And if people who know my background know that I am still a very successful lawyer, but I was very wealthy, and I was rolling. And when they shut the economy down in California during these lockdowns, my firm had dumped millions of dollars into billboard ads, and with hardly people traveling on the freeways, it just wiped us out. So I'm rebuilding the firm, but in the interim, I met Chili, and I think part of it was just the depression and all the stuff that I was going through, seeing how this guy keeps coming back. And I introduced him to Dick Heller, and when he got locked up, I was able to help him a little bit with his channel, and one thing led to another, and now here I am with my own channel. So I just want you guys to know I'd never do anything to try to hurt my friend Chili. I think he's a good guy, and I think he has a good heart. I think he has a lot of things that have happened to him that make him the way he is. And although him and I are different in many ways, we're alike in many others. And one thing I know about him for sure is that he's brought a lot of help and a lot of well-needed love to people who are suffering out there. So give me a bunch of ones for Chili one more time. Oh, wow. Dick Heller's channel got deleted. That's crazy. Well, that makes sense, because we know that YouTube and stuff, they're going after anybody that believes in the Second Amendment, and they're really pissed off about the Supreme Court justices that just keep passing laws that make it easier for Alan Beck and I to keep winning our Second Amendment rights cases. Alan Beck was able to get Hawaii's CCW law upheld to stand for the people, and a lot of really great things have happened. So, and a lot of that has to do with Dick Heller. Chad Crum, good seeing you. Shock Prof, always. Dan Glick, all you guys, super, super great seeing you. Jody Shiloh, love seeing you here. What's the matter, you, as always? I always want to give everybody thanks for showing up. Burn Thy Priest, thanks for showing up. What legal dictionaries do I use? Well, Burn Thy Priest, actually, I have an old leather-covered edition of Black's First, and that's my favorite. A lot of you guys don't know this, but I am one of the original so-called sovereign citizens. Like, I'm one of the very original guys. I knew who the Freemen were of Montana, and I was one of these guys that would go to court and fight traffic tickets all the time and win. And Bob Schaefer was a very good friend of mine, God rest his soul, and he was in San Bernardino, California. I also knew Eric Richard Williams. He was another amazing pro-natural law guy. I think he passed away years ago. But ultimately, I learned my lesson out of all that if I kept just getting locked up and kept fighting the system the way that I wasn't going to get anywhere. And so what I learned is you can fight the system from within and be far more effective, but you just can't forget where you came from. And so what happened to me recently brought me full circle. And here I am doing my channel now to a large degree because of guys like Chili. And then all you other guys saying, hey, come back on YouTube after Chili got released from jail. Because I was like, well, maybe I'll just post personal injury stuff and just, I'll be done with it. But then everybody's like, no, do more of these, cover this cop watch video and cover this, cover that. So even though that's what I do, guys, I do personal injury law. Okay. So this is not the kind of law that I really practice anymore, but I'm really good at it. So I'll cover this stuff for you. Just for you people who think that I'm coming on here because I'm trying to get cases and stuff. I've never gotten a case from YouTube. I've had people try to send me their cases that would have cost me a lot more money than I could have made as a lawyer working on them. But I have not gotten any cases from YouTube. I have made a little bit of money from super chats, and I've sold some of my books. Hopefully that's motivated people, and that keeps my wife off my back. But this is not a money-making venture, just so you guys understand that. This is something that I do as a labor of love. And I've invested a lot of my own personal time into it, and had these scumbags like Dick Bag and all of his low-life friends try to cause trouble for me in my business because apparently they don't have anything better to do. But I am a legit lawyer. I've recovered millions of dollars for my clients. And for people who say, oh, you're not a legit lawyer because we looked you up on Google and couldn't find any of your cases, I just want to clarify something for you guys, because there are so many people with IQs of like -3 apparently who have channels. 99% of cases, including lawsuits, are not going to be on Google. Okay. You'll find them by going to your local Superior Court website, logging in with your bar number, and paying a fee. And that's how you'll find the cases that lawyers have done. So in order to find all my cases, you'd have to log into every single, the filed cases, the litigated ones. You would have to go into every single Superior Court website in California, pretty much, because we've pretty much done cases in every courthouse up and down the coast. And you'd have to pay a fee. And most of the time you'd have to be a member of the bar, and you could pull those cases. And in federal court, you'd want to have access to PACER. So you don't find people by going on Google and Googling their name. There are some case reporting companies that will cover some of the cases that you have. But beyond that, most lawyers don't try cases. So most of your verdicts and settlements will have been non-public matters. And many of mine are confidential settlements. For example, we got it was either 10.5 or 10.7 million for a motorcycle accident case. Guy was former Army. I think he was airborne, but the defendant was a very famous company, and we had to structure the settlement to make it confidential because they're always afraid of copycat lawsuits. So all these idiots out there who think they know stuff, I just want you guys to know that they really don't, and they're really dumb, and you should treat them like who they are, complete idiots. Now, beyond that, you guys got to know that, because it just cracks me up. Like, because they think they're so intelligent, and you listen to them as a lawyer with 20 years in. I'm just like, who are these guys? I mean, and the stuff that they say is defamatory and false, and it paints me in a false light. And I don't think they realize how long the statute of limitations is for the things that they're saying about me, because they're going to have a freight train coming their way pretty soon. But beyond that, let's get into the Lane Meyers case. And we're going to talk a little bit about what happened with Lane. And I'm going to play the beginning for you while I go and get the air conditioning turned on, because I've got all these lights on, because Chili told me, get all these cool lights, man. Right on, Chili. Chili's listening as he's driving. Cool, Chili. Right on, bro. So we're going to go ahead and we're going to go ahead and start the first part of the video. And then I'm going to talk a little bit about the Arizona law of recording in court, because a lot of you guys misunderstood what happened here. Okay. This guy didn't like humiliate anyone to be able to record in court. He got the head judge of the Superior Court's permission to record, because he's smart. He knows what he's doing when it comes to procedure. And that's how he did it. It's not some secret. You can't record in court in most courts in this country unless you get permission from the presiding judge. And that's what happened here. So we'll start the beginning. I'm going to go turn the AC on, but I'll start the beginning so you guys can watch. All right, let's get it going.
This is a public service.
Ms. Jane. Mr. Meyers. We're in the matter of Stacey Jane Plaintiff versus Lane Meyers defendant. Appears both parties are present. My name is Tom Burning, of Tucson City Court Magistrate.
Thank you.
I'm here to preside over this matter. I have just received, I don't know if you received, Ms. Jane, a copy of notice of audio recording.
I did not, but I plan to make an objection at the top of the hearing about recording.
There's no objections allowed under 122H, sir.
And what is the purpose of the recording? Is it you say this is your own personal recording, your own personal use?
Personal audio device. Captain Honor near the person.
Anybody can make an objection.
I get what you're saying, though, but like, I've been going through this at every hearing. Let's move on with the hearing.
Now, let's talk about it first. Rules require hearing. Just tell me what your position is
On what?
on whether or not I should permit the recording pursuant.
You
to
don't
the
have
request.
authority to stop me. It's a Supreme Court rule.
Okay.
The presiding judge has already given me a court order that says I can do it. So what do you want to do here?
Do you want to hand me a copy of that?
Yes.
So that's what he said is the trigger, guys. That's why. Now, by the way, I want also to explain something to you. The litigant here continually cuts off the judge and interrupts, and he doesn't allow a proper protocol with respect to arguing motions or arguing your case. You don't cut people off mid-sentence, especially the judge. And so the judge is showing great deference to him, in my opinion, because he is a pro per litigant. Because if any attorney had done that, they would acted the way that he's acting, they would be immediately found in contempt of court and probably be thrown in jail. So I just want you guys to understand the judge is showing him great deference. And I'm going to share with you the case law in a minute as to why I think the judge is allowing him to do this stuff. But I just want you guys to back off on this whole idea about people are being humiliated. That's not the idea. That's not why we go to court. We don't go to court to humiliate people. And by the way, this person, this woman, Stacy Ruprecht, she's a girl. She's a woman. So I'm a man. So I don't have any reason to flex or try to humiliate some lady. She's a law professor. She's not somebody who probably practices law. And clearly, she doesn't know the substantive law in many areas as well as Lane does. It's obvious. All the more reason to be that much more civil and kind. And I'll get into that in a little while. But it's just more of a personality issue with me. I just, I was like him 30 years ago when I would go into court. But as I've matured, I've realized that it's better to try and get the respect of the people, even if you disagree with them. That's just me personally. Okay. I mean, I've got nothing against this guy. I think that he's pretty snappy. He's pretty good.
It's called Administrative Order 50-4.
Okay, well, let me see yours.
You look at it's signed by your presiding judge. You're required to follow the rules, not me.
I'm going to follow the rules.
All right, good then. So let's move on.
Don't tell me how to run the courtroom, sir.
There's multiple people in here that are going to be recording,
Well,
and you're not going to stop us.
I'm not.
No,
Your Honor, I would object to any recording in the courtroom by
she doesn't
Mr.
have the
Meyers
authority
or
under
by others in the
122H. We're not going to
courtroom.
divulge this. This is a waste of both of our time. You can continue if you want to debate this. Continue the hearing.
All right. We'll continue the hearing for a separate hearing on purposes of 122.
To what?
For hearing on.
Yeah, because I'm going to file an injunction against you
Okay.
to enforce 122H at Superior Court. I'm going to go get an injunction
I'm
right now.
asking, do you have a copy of the rule that you would like?
Do you have a copy of
I can
122H?
get a copy of the rule.
Pull up 122H.
Don't
You guys
yell.
got a copy of it?
There's no need
Here, I'll
to-
pull it up. Can I pull it up on my phone and show it to you?
Sure.
Okay.
I mean,
I've been going over this in every court in the past 3 months, and I've come out successfully every time. And any judge.
And by the way, the backstory, if one of you guys can share this with me, I'd like to hear it. But what it sounds like is that he had originally reached out to her. I guess she's with the Department of Education or something. And what I guess was trying to get some information from her. It didn't work out. They got into some kind of a problem. And then ultimately, what it sounds like is she got his wife fired from her job working for the federal court system. That's what it sounds like. So I just want you guys to understand that if that's the case, I can understand why he's furious. So I'm not right. Lane, I just want you to know, bro, I don't know everything about your case. I'm more here to talk about the procedural aspects and how I would have done it differently to achieve perhaps the same or better result. But the proof is in the pudding. It sounds like you won. So I think that's the most important thing. But I also think that the issue is you're probably the only guy who could ever do this and get away with it. And these other pro per litigants that watch my channel, they're going to think that they can copy you and they're going to end up getting locked up, in my opinion. And so I'm going to teach a different methodology as we go through this. Number one, when the judge speaks, you always let the judge finish speaking. Number two, when the other side's speaking, you never cut them off. You always allow them to finish. That's just proper courtroom decorum. It's not like YouTube where people keep talking over you. So the only way you can even say anything is to keep talking. And this also, it wastes an enormous amount of judicial and taxpayer resources because it prolongs the proceedings. But let's get into it.
That tried to stop me got hit with a special action. So
Well, you can hit me with a special action. That wouldn't bother me.
it's an administrative thing. You do not have
Okay.
judicial immunity for administrative decisions, and these
Well,
rules fall under judicial.
I'm asking you just to.
I'm gonna show it to you right now.
Okay.
50-4, or excuse me, 122H, 122H. I cannot believe you're letting this hearing start into this. You're biasing the jury. You're the jury, sir, and the judge. Right now, you don't have 122H hearings before a matter. Now this is prejudicial against me, sir, because.
So I don't know that that's true, that you don't have a 122H hearing. And I don't even know necessarily that's what you would call it. But just so you know, the rules for recording in court, hold on. The rules for recording in court in Arizona, and by the way, I'm only licensed to practice law in California and Texas. So I'm telling you guys this from my perspective as a spectator. I'm not giving you legal advice. I'm just going to repeat what the rule is. The rules for recording in court in Arizona, the Arizona Supreme Court has promulgated these rules, and one of them is Rule 122. And basically, it says that you have to have permission to record, and to photograph or broadcast in the courtroom requires prior approval. A person must submit a written request to use such devices at least 3 business days in advance of the proceeding if they wish to record. The court may waive this requirement for good cause or in extraordinary circumstances. Now, I don't know what those would be in Arizona. Judicial discretion. The presiding judge has the authority to grant or deny that request. And it's based on specific on-the-record findings of potential harm. That's one of the reasons. Factors could include the impact on the right to a fair trial, the privacy rights of parties or witnesses, safety or well-being, distraction from court proceedings, adequacy of court facilities, and timeliness of the request. So, if you've got minors in there, obviously they don't want stuff getting recorded. If you've got confidential informants, witnesses, you don't want to have them recorded. Now, there's limitations when the court's not in session. If someone wants to use a recording device when there's no courtroom in session, they have to get express permission from the presiding judge or an office authorized by the judge, like the marshal, for example, I think. And there are prohibitions that, there's no recording allowed when the judge is off the bench unless the judge specifies otherwise. So when he leaves the courtroom, you have to stop recording it. Jurors cannot be shown or recorded in any manner. That's one of the reasons why they don't allow it, because they can be targeted. Imagine those mafia guys, right? Like they could, they'd have an ID and be able to take out the jury. Jurors must not be shown or recorded in any way, including audio of any of their statements. So if the jury's polled, or during voir dire, you can't record that. Juvenile proceedings is going to be limited. And then any video, photographic, or audio evidence proceedings obtained under this rule cannot be used to modify or supplement the official court record, okay? And then media coverage, the typical rules are going to apply to them as well. So I just want you guys to kind of understand what the rules are of recording. Now, in this case, he only obtained permission to audio record, and that's going to come in to import later. And of course, the female attorney, the law professor, she's complaining about it, but I do agree with him. I don't think she has a leg to stand on. She's objecting to it. She has the right to make her objections. If I can give any sort of criticism of Lane, he should just let her make her arguments and then make his objections and arguments after she's done. So typically the way I do it, especially when I'm doing an appeal and the other side's up there on the bench, is I take my yellow pad and I listen to everything they say, and I make bullet points of each thing that they say. Otherwise, I'll forget. And that's probably what he's doing. He's calling it out right away because he might forget a valid point afterwards. But no, you just get your pad out and you break down each point, and then you get up on the podium and you go, Your Honor, with respect to argument number 1, where she said she's objecting, there is no standing for her to make that objection. This has already been granted by the head judge of the court. So she has no legal basis to make that argument. And then argument 2, and so on. And then you do that, and that moves the proceedings a lot faster. And it also lowers the judge's temperature. And in this case, it looks like it's a trial by judge. So he was right that the judge is like biasing himself if he does allow a hearing on recording in court when it's already been pre-approved. So I'm just telling you, that's how it would be in California. Okay. So, and then as far as contempt goes, yeah, there is criminal and civil contempt. But I don't know what it would be in this case, but in a civil contempt, I don't think you can get locked up. So, and it's based on multiple warnings, typically with a pro per, but we'll get into why in this case, I think the judge granted such deference, but typically you would never swear in court. That would go against proper judicial decorum, and it would definitely bias a jury and the courtroom staff against you. And believe it or not, having the courtroom staff on your side, a lot of times, believe it or not, they're rooting for guys like me and Lane because they've seen people get screwed. So one of the things I have to tell you is please don't judge people too harshly. Sometimes you'll find allies that you never thought would ever in a million years be your allies. And I'm not going to get into how I know that because I don't want to mess up anyone's jobs that are due for retirement. But believe me, there are people in the system who are probably your greatest allies. And last thing you want to do is bias them against you because they may be more pro-Constitution, more Bill of Rights than you, but also be like, shit, I got, kids in school and I got to support them. I'm a clerk. I'm a court reporter and, here I am. Maybe I can do some good from the inside. So now if you're a purist and say, oh, if you're in the system, you're evil, you're bar, you're this or that, I can't help you. But if you're somebody who believes in the human condition like I do, then just listen to what I have to say because it's true. It's the reality. Let's get into it.
Because you and I are having an adversarial conversation before my hearing where you need to decide on my credibility and my, whether I'm.
Are you going to show it to me or not?
Yeah, I am.
All right, that'll be sufficient for the moment.
Because I just had a Superior Court judge go over this.
Okay, well,
I'm
that's
not,
fine.
you're prejudicing my case right now. You're prejudicing me. It's literally on your own website.
Well, I'm sure it is. I don't have the president in front of me, so.
That's why I gave notice ahead of time.
I just got the notice like 30 seconds ago.
Because that's all I need to do is.
Okay.
So I do see some comments that a trial by judge is not constitutional. And what my understanding is, and look, you guys could be right, but if you're not risking jail, you can stipulate to having a trial by judge. And that happens in many cases. Typically, the only time you would have a trial by jury is if you're facing potential criminal punishment or like a cruel and unusual punishment of an incredibly large fine. But most of the state constitutions, and I'm a 10th Amendment guy, say, no, you can have a trial by judge, and the Supreme Court has upheld that in certain cases. So if there's no confinement, which is probably another reason why the judge is going easy on him. By the way, I love his bow tie. Give me a bunch of ones for Lane's bow tie. I mean, the guy's definitely a charismatic dude. And again, anybody that's got balls like that is automatically an honorary member of Team MPE, because that is exactly how Mike Eline was about 30 or so years ago.
It's how you and I walk in.
I'm sure that's fine. I just, as a favor, I'm asking you. So
I'm
I can
showing
look at
you
it.
right now. Here you go. 122. There you go. H. Go
That's
to
a lot of
H.
those recordings, right?
H. Hey, why is this guy video recording? You get what I'm
No
saying?
cameras yet.
No, look, seriously.
I just said.
No, but there'll never be video recording. Video, you do have to put in a notice ahead of time. My bad.
And two, I just told him to stop.
Okay, but no, he should be held in contempt and removed from the hearing. He just said, fuck you, punk, to these people. This is, get an officer in here, sir.
Hey,
This is
the
my,
rest of you, I allow.
this is my party. This is my family.
That's great that your family.
So why is this guy attacked?
So apparently, like a family member or a friend of this law professor had like an adversarial guy show up and he starts videotaping. And Lane is correct. There are signs posted all over the courthouse, at least in California and Texas. I'm assuming it's the same in Arizona, saying no recording. It's punishable by criminal fine. Now, whether or not the judge can find this recorder, the person who's recording, in contempt, typically to find someone in contempt, you have to be given a warning by the actual judge in advance. And then once you keep doing it, then you can be held in contempt. Now, look, there may be some legal scholar in my channel who knows more than me. Shoot me the case law. I'd love to go over it with you. But I think that the guy should have been removed from the courtroom. I mean, you don't sit there and say F off to one of the party's families. By the way, you'll notice that Lane swears a lot. And that's something that you never want to do. When I teach my CCW courses, I always tell the people, the ladies that I teach, that you never want to like say, get back, you effer, never use cuss words, because any witnesses will automatically think that you were the initial aggressor, right? So if you're acting in self-defense, you never, ever want to swear. And the same goes in a courtroom. If a potential juror, in this case, the judge, hears you cussing and swearing, they automatically think that you're an aggressor. It's human nature. So that's one of the things that I really, really want to like impress upon all of you guys, is to hold your tongue. The court, just I know a lot of you guys are going to like want to argue with me and tell me that I'm a bootlicker or whatever, but what I'm really trying to do is save you guys and help you become better litigators and better pro per litigants so you can be more successful and win over people that would otherwise be your enemy. And the less enemies you have in the court system, the better for your sake, in my opinion.
Using cuss words at my family in the gallery.
I have no
Why is he
idea.
filming?
Do you want to have the hearing or not?
I do.
Why is he still sitting in here?
Why hasn't this man been removed when he's in violation? Sir, if you want to video record, you have to put a notice in ahead of time. We're not trying to video
Okay.
record. This man just pulled his phone out when there's signs all over the building when you walk in that say no video recording allowed. This man just pulled his camera out in this court and pointed it at us and recorded you at the bench right here without a notice. And then he said, fuck you to these people, and you haven't kicked them out yet.
Because I haven't had a hearing or known anything about it other than what you're telling me.
You just watched him.
Okay, are you gonna listen, are you gonna participate?
Absolutely, sir. This is
Then have a seat.
Thank you. Are you at my phone? And
I
we're
do
gonna.
have your phone, I'll give it back to you, but you haven't given me an opportunity.
Is
to
it
look at
still open?
And the rest of you folks,
Is it still?
let's go.
It's still open.
I don't need-
122H personal audio recording. No
Okay.
video, sir. We
Okay.
agree, no video.
I agree.
Nobody's trying to
Okay.
do video.
I'm trying to reach.
Except him right there. And we need a copy of that video. You need to order him to give me a copy of that video or delete it in front of you. This is how it works in here. We've been dealing with this for many years.
So just so you guys know, if you start talking to a judge like that, judges are human beings. And whether he's a judge, magistrate, or whatever, he's empowered by the judicial system to preside over that case. So I would tell you to wait your turn, let the judge make his ruling, and then make your argument after the judge is done. Don't get into an argument with the judge. It's going to poison you with the court. But look, he's not a lawyer, so I can't sit there and criticize him as if he was. So I just want you guys to know that I'm not attacking him. I'm trying to help provide some information that could make him a better litigator in the future.
Judge Klotz and Judge Riojas, you cannot film video in here. That's a crime.
Okay.
He should be arrested, just like we get arrested if we video in here.
I'm happy to delete it.
It's deleting it.
Oh, look how easy he's just, hey, sir, can we video? This guy, man, is videoing in the courtroom.
Let's not video on the phone. I just deleted it. I didn't know, you were. I thought
There's
you were-
signs everywhere.
Okay. Hey, Mr. Meyer, you guys, I
I
said.
said, been kicked out.
We would have already been
Okay.
there.
Been kicked out, Your Honor.
Sir, permission, I'm not.
No, Okay.
We would have already been kicked out though.
okay, that's fine. That's
Here,
a different book.
we want to follow the rules.
Sir, you're gonna be removed if you do not remain quiet. Don't tell me what to do.
Please, sir, can we just all calm down and cooler heads prevail and all of us be
Okay,
grown-ups
well,
in
it
here?
would help if you let me read
Thank
the
you.
rule.
You guys, let's all just be grown-ups for a minute.
So the judge is saying it would help if you'd let me speak. So far, I'm going to tell you I'm giving the judge a 10 on keeping his cool, because most judges I know would have already thrown this guy in contempt. So it's something you need to think about. I mean, honestly, I've never seen a judge act this cool. So as far as owning the courtroom, I think that the judge is giving great deference to this man, probably because he has a reputation for being a firebrand, and the judge doesn't want trouble because he doesn't know what's going to happen. And remember, judges are also elected officials, and this is Arizona. It's an open carry state. It's a shell issue state. And this is a man's man type of a state, right? I mean, these guys, trust me, there's a lot going through that judge's mind right now. Let's keep going.
You're not allowed to record in this matter. You
I
understand that?
understand. I deleted it. I deleted it off the recently deleted. I'm happy to.
And
show
did you use any profanity with those folks?
What's that?
Did you use any profanity towards any of those people?
I did,
And why was that?
because I felt like I was being harassed. They were telling me what to do. We were showing you the rules. They're telling you.
Did I ask you to talk? Okay, you may get permission to talk about the.
On that side. There was-
Hey,
Not one person swore over here.
Would you?
Not one person used profanity. He did.
Sir, allow me to release control my
Thank
courtroom.
you, sir. I appreciate it.
I was actually talking to a person about the concerns you expressed,
Thank you.
and you keep on constantly interrupting me while I'm trying to do that. And I don't know what is the purpose of that. One,
Right. So
you
yeah,
are not
so-
allowed to video.
So just really quick, I don't know if you guys noticed. So the original case, again, it was an audio recording. So this video that I'm showing, and Lawyer Dog is rightly pointing out, comes from another case. And hold on, I'm going to try to find the video. And it's the name of the dude is This Is a Public Service. And it was recorded 3 days ago. And it looks like it's a courtroom camera recording of Mr. Lane. But I figured I would show you this. BZ Watchdog and I talked about this before we did the show, because I wanted you guys to have something to see so you get an idea of what his demeanor is. So if you think that it's off or whatever, because it's from a different courtroom proceeding, but give me a bunch of ones if you think it's better than just like looking at a black screen. Besides, at least this is the longest I think Chili's ever stayed in one of my shows. So clearly this must be a good topic and he must like it. Otherwise I wouldn't have him in here. Give me a bunch of ones for Chili DeCastro sticking around for more than 3 minutes to say hi. Thank you, Chili, for joining me today. Look at all the ones, Chili. They love you, man. Hail Caesar. All right, let's let it keep going.
You now know that. 2, you're on warning that any further disruptions. I understand you have concerns, whatever folks may say, and we'll pay attention to
Chili
that.
even gave himself some
But
ones.
you yourself, any further adverse actions in your could result in your removal from the courtroom, okay?
I understand.
And
Oh, man.
can I get the 122H now?
Is it still up the screen?
Yeah, it's still.
SWE Observer, good seeing you, man.
122H.
That's
You're
good day.
familiar with 122H?
I am not.
Thanks,
I
God.
would
It
like
does
to
permit the use
respond.
of a personal auto recording.
So
Chevy.
I point you to Arizona Rules of Protective Order Procedure 8A2, which requires a judge to ensure that the parties are treated with fairness, respect, and dignity and are free from intimidation, harassment, or abuse during the court process. In addition, Arizona Rule of Protective Order 38E says that the court must take reasonable measures to ensure the parties and any witnesses of the hearing are not subject to harassment or intimidation in the courthouse or on adjoining property. Mr. Meyers has live streamed previous court recordings and
Seeing you,
posted
Tiffany.
videos about me and discussing me on his YouTube channel.
Objection, Your Honor, that's not relevant to the complaint.
Let her finish.
She's going outside the bounds of the complaint. She's talking to things that are not in the petition. This is not a protective order. This is an.
So he needs to let her finish, and that's a real problem. Like if he was a lawyer, he would be disbarred for doing that. So just so you guys know, like it's totally beyond the scope of what a litigant should do. And if I was teaching him how to be a lawyer, I would like I said earlier, I would have him get out your notepad, write down each one of her points, and then destroy her after she speaks. It'll give you way more authority with the court. And the court's going to go, holy crap, this dude is like freaking legit. This guy's like Maximus. By him doing that, he's showing his lack of knowledge of understanding of the court rules. And it makes him appear to be not educated. And it actually is working against him. But despite that, and I'm going to get into this in a little while, the court is still entertaining what he has to say and the court's doing his best not to go bananas. And again, most judges would have already kicked him out of the courtroom or held him in contempt for this type of behavior.
Injunction for harassment. Those rules do not apply. 122H applies. I was just at an injunction for harassment. hearing at-
Sir, would you let me listen to her first, and then we'll have the opportunity to speak?
The videos posted by Mr. Meyers have also prompted other videos on YouTube about me and
Sir,
have
she's
prompted
litigating the
people-
case. She's litigating the case right now. So you cannot allow yourself to be prejudiced by you.
Sir.
This shouldn't even be happening right now. This argument about 122H shouldn't even be happening. And you're allowing her to make arguments about a protective order, and she's pulling out legal jargon that is not applicable here. And she's talking about videos that are not in the petition. They're not in the petition. She's prejudicing my fair trial right now, and you're allowing it. This is all on the record for appeal. The transcript will show you're allowing her to talk about a protective order at an injunction for harassment hearing. Follow the rules. This is a civil procedure. It's not a protective order.
I'm not
It
finished.
is a civil procedure. It is a protective order.
It's not a protective order.
It's not a,
It's ARS 13.
yeah, they're called protective orders.
Come on,
Let her
man.
finish.
Arizona Supreme Court Rule 122D says that the
Thank you,
judge can deny
Chevy.
a request to record or live stream a proceeding
A
in a
request from
courtroom
C.
if the recording will negatively impact a party's right to privacy, safety, or well-being, or based on any other factor.
Right. But the problem is it's too late. So I just want you guys to know, despite the fact that I know that he's acting out of line to the rules of courtroom procedure in not allowing her to finish, because again, he could seek an interlocutory appeal. He could file a writ. There's a lot of things that he could do, but cutting her off and not letting her speak, it's losing him credibility with the judge. That's just the way it is. And the judge is the one ultimately who's deciding this case. Now, if you're somebody like a Chile who's got an army of appellate lawyers, then go for it, because you can win an appeal, but not everybody is a stud like that. Where, like Chile is the exception to the rule, and maybe Lane is the exception to the rule. But for you other guys, don't think that you're going to go in there and take names like this dude. I just want you to know that it's not going to happen. So again, the Arizona Supreme Court has already said that if you get prior approval from the presiding judge, you can record. So everything that she's saying is moot. She should have made these arguments prior to the hearing. And my understanding is in court cases, from having done thousands of them, that what happens is you're served with copies of motions and pleadings in advance by the other party, or it will be available on the court's website if they're that advanced. They're not caveman, right? So she probably already has a copy of this 122A petition, and she should have objected to it and filed an opposition brief in advance. And so Lane, I believe, is correct in his interpretation that she's out of line. The issue that I have with Lane, like any proper litigant, is he just doesn't have the experience. And that's why he's cutting her off and basically pissing off the court. And again, I know you guys love it and it makes for a good YouTube video. And hey, I love it too, because, I'm all about the First Amendment. But as a lawyer, I'm just telling you from my perspective that he is not following proper courtroom decorum, and it's going to work against him, or you especially. Now, in his case, he seems special. He may be surrounded by guardian angels and be filled with the Holy Spirit. And that could be what's causing the judge to back off on him. Trust me, there are principalities of power and spiritual energy and things that you don't see that only the very discerning can see. And that could be what's happening here. And I know a lot of you guys are going to say that I'm crazy for saying that, but no, it's true. Let's keep going.
Affecting the administration of justice. And Arizona Supreme Court Rule 122.1E says the judge can deny the use of a portable electronic device in a courthouse if use of that device is contrary to the administration of justice. And for those reasons, Your Honor, I respectfully request that both Lane Meyers and other participants in the courtroom today not be permitted to audio or video record this proceeding, particularly because it will end up on YouTube and I will receive phone
I'll tell you
calls.
what, we'll turn our recordings off if you turn the court recording off, because it'll go on YouTube whether it's, I order it for $17 and have it by the end of the day or not.
Would you allow me to? Thank you. I believe Mr. Myers is correct in regards to 122 in regards to personal auto recordings. Obviously, no video recordings are allowed. Everybody got that? This matter is in fact audio recorded by the court. You are allowed to personally audio record it yourself. If you do so in a disruptive manner, that will be a separate issue. But for the moment, we'll assume that we're going to abide by that rule. Is that okay?
Thank you, sir. Yes. Thank you. Can we please get back to?
Could you please quit telling me what to do? I'm allowing the lawyer to speak. Let you speak.
You allowed her to prejudice.
Okay, would you quit? Is there anything you want to state in advance?
I would like, if possible, to start the hearing discussing the parameters of the issues before the court and the objections I plan to make.
You'll get a couple minutes and then you'll get a couple minutes.
I thought we start this by, she needs to be sworn under oath.
Well, she's not testifying yet.
Hold on. Point of order. Point of order. So Lawyer Dog, my honorable friend Lawyer Dog, says that Greg got his days in jail for contempt, and guess what happened? The judge got reprimanded. So I don't know if that's this guy. Maybe you're talking about Greg, another Greg. Is this guy's name Greg? Hold on a minute. His name is Lane Meyers. So this is a different dude, I think. But guys, listen. People get locked up and falsely imprisoned all the time. And only the ones that have the money basically are going to be able to win. So lawyer dog, the point I'm trying to make, brother, is unless you're rich, dude, learn how to do it in a way that's not going to give the court an excuse to lock you up. Because trust me, a lot of these judges would love nothing more than to see you get locked up, hoping that you'll go bankrupt. And my right honorable friend, Chili DeCastro, I'm sure could testify to that as well. That if you give a judge an excuse to lock you up, they're going to take it if they don't like you. Now, that may not be all judges. And in this case, I think that this judge has been pretty fair because he's letting Lane get away with what no lawyer could ever get away with in any court that I've ever been in. So I just want you guys to understand, if you go in there like that and think you're going to get the same result as Lane, you better make sure that you have a history of winning. You better make sure that you have millions of followers. You better make sure that these politically appointed judges know that, you know, they're going to be the ones all over YouTube, right? I mean, and I'm not suggesting that you do that. I'm not professing that that's the way to win a case, but I'm just saying that a politically appointed creature is a political animal. And so unless you have a political machine yourself, if you're just a Mike Eline from 30 years ago going in to fight a traffic ticket, don't expect to get deference from the court if you act like this guy. That's all I'm saying. Just order in the court, Stomper. So, and I'm not putting anybody down. You like that? Point of order. I'm trying to sound like the British. My right honorable friend. I by the way, I love the British parliamentary. Tea time.
That's what she's about to do, testify. Any words she makes moving forward from the next moment need to be under oath. You don't get no free statements in a court hearing. Put her under oath and let her.
To swear affirmative testimony will be the whole truth, nothing but
Who?
the truth. Yeah,
I'm not under oath yet. You said it starts with her. The burden's on the plaintiff. Start there.
yeah, sure. Affirmative testimony will be the whole truth, nothing but the truth.
And that is true in California and Texas. The burden is on the party asserting the matter to be proven. Think about that. So I got to tell you guys, I mean, Lane really has the substantive law. In my opinion, he knows what he's doing. He reminds me a lot of my friend Dan Tankersley. He was a very, very famous legal scholar years ago. I know he had some heart issues, but, you know, thousands of acres, a rancher, wanted to be left alone, kind of like a Freeman type, but more well-spoken, well-reserved, but the same knowledge of law. And like, you could tell that he was just like totally filled with the Holy Spirit. Like one of these guys were like beams of spiritual energy just like shot out of his eyes every time he spoke. Like you could tell that this guy was a special man. Let's keep on watching Lane and see what he's got to say.
Okay. Did you have an opening statement?
Your Honor, my understanding of today's hearing is the issue before the court is whether Mr. Meyers' conduct amounts to harassment under AS 12-1809, defined as a series of.
Stop for a second. I just thought of something else. There's a second case involving you. Is that right, Mr. Meyers?
With who? Today?
Yeah.
Yeah.
That has nothing to do with this case, right?
No, these are completely separate.
Okay.
The reason they put that today is because I'd already be here.
No, I understand.
Right.
Are you here on the second case?
Yeah.
I'm gathering it's possible we may not get to that. We'll see. But, see how long this. Oh, Mr. Meyers, you seem to be wanting to take some time. So
Take some time. I want to get through this kangaroo nonsense as fast as possible. I have things to do that are really important.
Well, then perhaps you can.
We just spent 15 minutes arguing about a circus. We just turned your court into a circus. She just turned this into a circus. I don't even feel like I can get a fair hearing today. Her person back here, we're here complaining about the person she brought with her has the audacity to start the hearing out by cussing out my family and video recording. This whole thing is about First Amendment and video. So put her under oath, and she needs to testify to what's on the petition and nothing else.
She's under oath.
Okay, because you let her make protective order statements talking about things that are not on this petition.
Okay,
If you want to talk about things that are on this petition, you got to give me a chance to either adjourn the hearing or take time to go over her new statements. She needs to amend the complaint if she wants to talk about things that are on not in this petition. And you just allowed her, under the protective order thing, to make allegations that are not in this petition, and you did not strike them from the record.
Okay, thank you.
I believe that harassment is defined as a series of acts over any period of time directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. The conduct, in fact, seriously alarms, annoys, or harasses, and serves no legitimate purpose. I do plan to object at any point if Mr. Lane begins to testify to matters outside, whether the issue before the court, whether his conduct amounts to harassment. I'd also like to ask that not only that the protective order be enforced, but that it also prohibit Mr. Meyers in the future from having any direct or indirect contact with me in the form of social media, that he be prohibited from posting or putting my contact information, including my work contact information.
So talk about like, this is a law professor. I got to tell you, Stacy, you're wrong about that. There's a First Amendment, and he has the right to talk about it. I don't think that any protective order would ever be enforceable with respect to any of the things that you've just said. Now, maybe Arizona's different, but I don't think so.
And on any social media platform, and that he not through social media or otherwise directly or indirectly encourage third parties to contact me or go to protected locations.
I can guarantee you that I'm going to keep those videos up and make more. There's nothing you or her will do about it. She's an employee of the state of Arizona.
Okay. She's making a statement.
Is she done? Is that because she hasn't testified to anything in this petition or presented evidence of these allegations?
I asked her an opening statement.
So right now she's doing what's your typical housekeeping matters, right? She's just basically like just arguing to the court, like, look, there's like almost like motions in limine in a way. And the court has the authority to entertain this. The issue with Lane is he keeps cutting her off and like, kind of like making disrespectful comments to the judge, like kangaroo court and all this stuff. So he's not like engendering himself in any way with the court or the court staff. So like, for me, that's not the way that I would do it. I'm not going to insult Lane and, tell him, hey, you're terrible. I'm not going to be like one of these frauditor guys and try to like, go after him, because there's so few men out there that have the intestinal fortitude to stand up for what they believe in. So if anything, all I could say, guys, is give me a bunch of ones for Lane for being a real man and doing what he feels is best in his heart for him and his family. Again, my understanding is that he believes that this woman is responsible for getting his wife fired from her job.
Did you have an opening statement?
We have to get through this. I just went through this last week. She needs to give her opening statement, and we need to enter the evidence in.
You have an opening statement.
As soon as she enters her evidence in.
Okay, you're reserving your right.
Sir, she needs
Don't
to.
tell me how to run the courtroom.
I went through these.
It's a problem.
Good, I'm glad you have. I'm just asking, are you waiving your right to give an opening statement? Or are you reserving it till later?
No, I'm going to give it right now.
Okay.
Put me under oath.
Well, you're making an okay. Do you swear affirm any testimony you gave the whole truth and the truth?
Yes, sir. Under the penalty of perjury. Make sure you say that to the next witness or the next case too.
No, that's okay.
It is under the penalty of perjury, right?
Well, there are laws concerning perjury.
All right, because that oath means something, right?
It does.
Okay. So she claims no legitimate purpose. Okay. She is an employee of the state. Second of all, there was clearly a legitimate purpose. First, so when are we going to discuss this? Because my opening statement shouldn't be about what's in the petition.
Okay, you want me to have her testify?
Well, that's what I'm saying is like my opening statement is going to be, are we just here to saying I'm here to contest this? Because I'm here to contest this because first of all, there was,
That's what it is.
she put an incident on here that was from 2.5 years ago. So automatically, and this woman, let's make some judicial notice of adjudicative facts. She's an attorney.
By the way, guys, help me out. Hit that like and subscribe button and double tap the screen because we are in vertical mode. And for all you youngsters that are out there, joining me from the shorts feed, stick around and watch and learn about your rights. Learn about what's going on and take what I say with a grain of salt or take what I say with high regard. But either way, stick around and see what's going on out there in the world. Stop spending your time playing stupid video games. Start learning about your rights. You have a very short period of life on this planet. Start standing up for what's important. Make as many babies as you can and make sure that you learn how to fight for them and make the world a better place for them.
Attorney, an Arizona member of the bar, and was a law clerk for 13 years at the federal court. She knows how to read a legal document, and where it says no items outside of 1 year, she put something for 2.5 years to prejudice this, okay? Why would somebody with a law degree who spent a career reading legal documents put something that wasn't allowed to be put on this document if it wasn't willfully and knowingly an attempt to prejudice the person getting this hearing? You cannot put something, it's all within 1 year. 2.5 years ago, an email where she said, thank you and have a nice day at the end of it. First of all, I had a legitimate purpose to contact her, and we're going to hammer that home today.
So you testify and making an opening statement?
Both. I'm making my opening statement.
Okay.
Because I'm here to contest this under LaFaro, Cahill and LaFaro and all this. First of all, she needs to prove 2 or more contacts within a year. So putting something 2.5 years ago, that's already written off. Okay. So then the next one you need to prove, she even stated.
So, and it sounds like he's right. She's pointing out conduct from years ago that would no longer be something that could be taken into consideration for purposes of granting the motion that she's filed. However, she is allowed to talk about prior contacts, prior conduct to show the totality of the circumstances in the relationship. So it's up to the jury to weigh the evidence, and it's up to the court to decide if the evidence can be used for, in this case, a finding that would support this motion for a stay away order. I'm not really sure how it works in Arizona, but the judge is right. I mean, she does have the right to talk about it, but he's also right. Lane's also right that the court can't use it to consider whether or not he's going to grant the order based upon contacts, right? It has to be based on contacts within a time period. So this is just another issue where Lane is substantively right, but he's also substantively wrong, because it's up to the court whether or not the court wants to use it as evidence. And if the court wrongly uses it, Lane's recourse would be like an interlocutory appeal on a question of law alone, some kind of a writ of prohibition or a writ of mandate, or a straight appeal. So he has a judicial remedy. And again, that's just something, that a lot of pro per litigants because they don't have the experience, that they won't understand that specifically. So don't think that you're going to go into court. If you don't have this judge, the stuff that he's done so far would be enough for a contempt order to have been issued. I'm just letting you know.
Stated herself, legitimate purpose. She's an employee of the state of Arizona, and the electronic harassment makes it very clear, which subsection C states, constitutionally protected speech or activity, or to any other activity authorized by law. So if she's if she's a state employee, I have a legitimate reason to call her and redress grievances. However, I have a legitimate purpose beyond just the default redress grievances with a public employee. I called her asking her specifically a question about her she started this program, Access to Justice, right? So I had some legal matters taking place in the county, and I called her up and asked her if she had any help for me about at the instituted whatever Innovations for Justice or Justice for Steps to Justice or whatever these programs that she creates to make it seem like she is helping people in the community. Where I call up there and I say, hey, Stacy, I feel like she should need to testify before we. So my opening statement is, I believe these were first point of order. She put something on there that wasn't allowed to be on there, willfully, knowingly, and intentionally in an attempt to prejudice this. Second of all, the two legitimate contacts on there that we can talk about on the petition that were within a 1-year time period, I believe are legitimate, whether she was a state employee or not. So let's let her testify to these contacts, and then I'll dispute them.
Why don't we do that?
Can I ask a question for clarification?
Sure.
Is the burden on me to justify the protective order should remain in place?
Absolutely.
Or is the burden on
The burden
Mr.
of proof is on
Myers?
you.
Okay.
Absolutely. You need to prove these allegations
I can answer the question.
beyond a reasonable doubt.
No, it's not.
Well, if she doesn't want to get hit with a lawsuit, she's going to have to prove beyond a reasonable doubt.
Well, that's irrelevant. to
Abuse
the
of
proceeding.
process, malicious prosecution, and all that. Yes, she's a lawyer and doesn't even know the burden of proof's on her. She probably didn't think this through very well.
That is true. I mean, what he's saying is
You're
true.
gonna make that comment?
This is deep.
I guess it is.
I guess we're not allowed to talk about what this all involves, though, because she doesn't want to talk about what happened and why I called her. But we're going to talk about it now, so I don't know how she can avoid it.
Well, she can avoid it if you won't let me to ask her.
Okay.
The burden of proof is on you.
Your Honor, I don't consider Mr. Lane's communication to me on December 2022.
2022, Your Honor, 1 year.
Okay, you can object to it. I'm going to hear from her first.
That's you cannot allow her to make statements that are not within the 1 year period.
That's
You have
not
to
true.
say, we don't have time. You're talking about we might not have the next hearing. You can't.
That's not true. The court has the authority to let her say whatever she wants and weigh the evidence and decide whether or not what she says, her testimony, falls within or without the statute. Now, by Mr. Lane saying we don't have time and all this stuff, that is beyond the scope of his power as a party, as a litigant. That is up to the judge to decide if there's time. So in a way, Lane is trying to usurp the authority of the court. And so again, be very careful, guys. If you guys do this, if you're not him and you don't have that particular judge, you could very well end up with the golden handcuffs on. So just be careful, guys. And I'll get into how to be more civil and understand why the court's giving him such deference in a little while. We'll talk about Balistreri versus Pacifica Police Department and the different rules that apply to pro per litigants, pro se litigants that are giving him the ability to have more leeway than an officer of the court would. But yes, I got to tell you, you can sort of tell she's a law professor and not really a litigator. Typical government employee, right? She doesn't even know that the burden's on her. That's pretty wild to me.
Let her babble on about things that are irrelevant, and I don't need to be sitting here interrupting you. If it isn't in 1 year, this petition was signed on 10 what? Because it's kind of scribbled 10/9, 10/7. What is the date? 10.
What's the relevance of
It was on 10.
Sir, I'm addressing your concern. What is the relevance of the? It is outside the.
I am trying to move through my contacts with
10/7.
Mr. Meyers.
No, you don't get to talk about contexts that are not within 1 year. 10/7. Run this.
I had the objection overruled.
I'm
Go ahead,
trying-
just briefly for context.
Trying to outline.
For context, no. Continue this hearing, sir.
What?
You're not going to give me a fair trial. You cannot there's no context to an act that took place outside of 1 year. It's prejudicial to my case. It's hearsay at this point, and it's irrelevant.
Hearsay is admissible in one of these proceedings.
She's not admitting hearsay in an injunction harassment.
So let me just tell you, just so you guys know, because I want you to know what hearsay is, because that is not hearsay. Okay, let's just get into it really quick. So I'm just going to give you an example of what hearsay is, and then I'll just get into the rules really quick. And I don't know the specific rules of Arizona. So this is another thing I want you guys to know. Like, if you're going to go into court, I want you to sound smart. Like, I want you to understand what the hell you're talking about. So hearsay is like when you're in court and say, I heard Bob say that he saw the whole thing. I heard Bob say something. I heard Bob say that he saw the whole thing. Instead of Bob being there to tell the court directly what he saw or heard. So it's you saying, I heard Bob say something. Nothing that she said is hearsay. It's her direct testimony about his contact with her. It's not hearsay. That's a statement by a party proponent. It would be like playing telephone with evidence. You're repeating what someone else told you they experienced rather than giving firsthand information. So that what she's saying is not hearsay. Okay, now he could object. He could say that it's not admissible. It's objection relevance, right? But it's definitely not hearsay. So typically, hearsay is a legal term referring to an out-of-court statement offered by a party proponent to prove the truth of the matter asserted. So she's not saying somebody told me that he posted something on YouTube. She's not saying somebody told me what she heard about something he said. That would be hearsay. So I just want you guys to know, because hearsay is secondhand evidence. However, another thing you guys need to understand is hearsay is not always inadmissible. Hearsay is admissible under the hearsay exceptions. And so I'm going to run down a couple of them. Give me a bunch of ones if you guys want to learn about hearsay, because I just really hate it that so many people just think they know what they're talking about and they don't even want to learn. And my goal is to make you better educated and make you understand what your rights are. So you're armed with truth. You're armed with the ability to defend yourself in this inherently legalistic system that we live under. Okay, so here, I'll throw some at you. Okay, here are some common defenses or exceptions to the hearsay rule. Present sense impression. Statements describing or explaining an event or condition made while or immediately after the declarant perceived it. For example, he's driving so fast, said by a witness. Like she heard someone say, he's driving so fast, right? That could be a present sense impression because it was said under the stress or excitement. So it's believable. So that's an exception to the hearsay rule. Or an excited utterance, which is very similar. Statements relating to a startling event or condition made while the declarant was under the stress or excitement caused by it. Like, he just shot him. He just shot him, right? So a bystander hears that. That's going to be accepted under hearsay. So it's admissible hearsay. So there's inadmissible hearsay and there's admissible hearsay. So don't just think it's automatically excluded. I want you guys to know your rights. All right. Or it could be a statement made for a medical diagnosis or treatment. Statements made for purposes of medical diagnosis or treatment describing medical history or symptoms are accepted under the hearsay exception. Or recorded recollection, a record concerning a matter about which a witness once had knowledge but now has insufficient memory, right? They got punched in the head at a boxing match. They can't remember anymore. So they can't testify truthfully and accurately. Shown to have been made or adopted by the witness when the matter was fresh in their memory, okay? Business records are typically going to be accepted as well. Public records, reports, statements, data compilations, that's going to be accepted as well. Activities of police officers, they can be accepted. Former testimony given at another hearing or deposition under penalty of perjury, that would be accepted, even though it's a statement made somewhere else to another person, right? It's hearsay, but it's accepted, okay? A dying declaration, a statement made by someone who believed they were about to die concerning the cause or circumstances. He shot me, right? 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 He told me that this person shot him. Well, that's hearsay, but it's accepted as a dying declaration. A declaration against interest, a statement made at the time the person is making it, so contrary to the declarant's pecuniary or proprietary interest that a reasonable person would believe that he would not have made the statement unless it was true, okay? A statement of personal or familial history, statements concerning the declarant's own birth, adoption, marriage, divorce, legitimacy, relationship by blood, marriage, or similar fact of personal or family history. Like, that's my son, I had it with her, right? You're at a custody hearing, that's hearsay. I didn't really have, no, that's not hearsay. You made it, and that's your kid, unless other evidence shows that it's not. A residual exception, statements not covered by other exceptions, but having equivalent circumstantial guarantees of trustworthiness. We can get to that in another show, but hopefully you guys are learning something, because, especially Lane too, brother, because I want you to know too, like what she's saying is not hearsay at all. It doesn't even need to be covered by an exception. It's her own personal contact with you, brother. All right, let's keep going.
There's no legal standard to talk about something that happened outside the 1-year period and an injunction for harassment, sir. We can turn this into a kangaroo show, or you can enforce the rules like every other judge in this county. You cannot talk about something for context. So I get to talk about anything I want then.
Welcome,
for
Grateful.
Context. I get to talk about how I think she got my wife fired for calling Judge It's context, right? It's context, right? My wife was a law clerk for a federal judge until I called her.
Have a seat.
He's pissing off the court.
Briefly tell me what's the
You
relevance.
cannot talk about something about.
I can ask you what the relevance is, and you made a relevance objection. I get to have, she gets to argue it.
What I was trying to say before Mr. Meyers interrupted me is that I don't consider the December 2022 contact to be harassment. It was included in the petition simply for purposes of identifying that the September 12th communication I received from Mr. Meyers was not my first communication.
Okay.
And that's admissible.
No,
All right.
it's fucking irrelevant. It doesn't matter if I contacted her 100 times before that.
It would not be
Thank you.
admissible.
I won't cuss again, but you can't just.
It would not be admissible to prove the truth of the motion or for the judge to grant it, but the judge could consider it as part of a prior contact to show that it's not the first contact. Now, it's really a wobbler. I mean, if I was the judge, I would not admit that statement because I don't see how it is relevant to proving any kind of harassment. That's just me personally. Like, if I was the judge, I'd be like, I don't see how that statement's proving harassment, ma'am. I mean, I don't care if it's your first contact or your 1,000th. The statute is clear under the substantive law that you've got a 1-year period, and this is outside the scope of the 1 year. And if it was before a jury, that would have been excluded during motions in limine for sure. The jury would not be allowed to hear that, in my opinion. I don't see how it shows any relevance. That's just me. Let's see how the judge rules on it.
Allow this thing to spiral out of control. There's rules to this stuff, man.
Yeah, well, why don't you try evading something?
Why don't you
Who's
try
going to
it,
hold you in check?
Well, I guess you can appeal. You can special.
That's all you care about, right? Oh, I guess you can appeal. My rights don't matter to you.
Yes, go ahead. That's fine.
My first communication within 2024 from Mr. Meyers occurred on September 12th when he called my cell phone to say he had an access to justice problem. I don't have anything to add beyond what's already in the petition with respect to that communication. On October 2nd,
Hold on for a second. Are you saying that what's in the petition, what was the date of that?
September 12th, 2024.
She's saying that she agrees I called there for a legitimate purpose, access to justice. She just testified that my purpose was
Are you
legitimate.
testifying now?
No, she did.
Okay, she's testifying. You're
All
right.
right. All right, go ahead.
That's not, well, thank you. Glad you gave me your permission.
I'm trying to be cool.
Okay, I appreciate that. Go ahead. So I'm just going to ask you, are you staying under oath this time with that statement from November 12th?
Guys, look, I've been in court hundreds of times. I can only imagine what the bailiffs are doing right now. They're probably just freaking out. Give me a bunch of ones if you think the bailiffs are just flipping out right now. They probably have like 3 or 4 bailiffs in there. They're waiting for him to do a stage dive over the podium, right?
Petition would happen.
Yes.
I have the recording too with me.
All right.
I'm not entering his evidence.
Mr. Meyers did record that September 12th communication without my knowledge or permission.
One party state.
I think that you'll get the opportunity. You don't have to interrupt the council.
All right, I appreciate it.
That's true.
So just let her
interrupt.
write this down, wait, let her go, and then come back after?
Yes.
That's what you're supposed to do. That's right.
On October 2nd, 2024, Mr. Myers live streamed a
That's not on the
YouTube video.
petition, Your Honor. There's the 2 dates on the petition are September 12th and October 4th. There's nothing about a live stream on October 2nd on this petition. This woman is not capable of following rules, it appears. And she's an attorney with the Arizona Bar Association.
Your Honor, Mr. Myers.
Well, with respect, he's not following the rules either. He's supposed to let her finish her statement. And then when she's done, like I said, here's how you guys do it, okay? You get your yellow notepad. Every time she speaks, you mark down everything she's done wrong. And then you, with respect, you argue to the court, not to her. She said this, she said that, she said this, she said that. This is why this, that, and the other is wrong, and why the court should not grant any, deference to anything that she said. But by him continually cutting off the litigant, the other party, he's basically, the judge is going to start siding with her. And that's what you don't want. You want the judge to rule on the evidence and rule on the facts. And when you constantly cut someone off and don't let them finish their thought, the jury and other people around you think that you're an a-hole. I'm just telling you. I mean, you guys on YouTube who constantly cut people off and never let them finish their thoughts. I mean, people think that you're jerks, to the point where other people start talking over you because you never let them finish. And so I'm just telling you, I'm going to get into a book that I want you guys to consider purchasing as well. And again, I'm not making any money off of it. And it's called Choosing Civility by P.M. Forney. And this was recommended to me by an appellate justice who I externed for back in 2004. But I'll show you that in a little while. Because I really, really think even in your personal relationships, choosing civility, letting the other person be right, when it's appropriate, obviously, if they've got a loaded gun and they're pointing it at their head, you want to make sure if the safety is not on to make them think that if the safety is on, you want to tell them that it's not, right? Don't want to give them the excuse to flip the safety to off. But typically you want the other person to always feel like they're right. You don't want to challenge them, especially in front of other people, because all it's going to do is make them hate you. And that's just human nature, whether you're in court or whether it's in the real world. Let's keep going.
Myers has now made multiple disparaging comments about me during this hearing. And
Saying she's a member of the bar?
Okay, so let her testify, sir. Would you please do that?
Can you please let this woman follow the rules?
You can tell me of her contacts with you.
She cannot talk about anything that's not in this petition unless she wants to amend the petition and add the new events. Okay, I have the whole rule right here.
Okay,
She just said on October 2nd. All right, I won't yell.
You're yelling, and would you quit interrupting?
But don't you have a copy of this in front of you?
I haven't. I'm asking about it.
So why is she talking about something other
Well, I'm
than
about to
September
find
12th
out.
or October 4th?
If you want to
She's
move-
attempting to prejudice this case.
If you want to move the striker after she's finished
Thank you.
testifying,
Thank
then you can do that.
Thank you.
Please do not interrupt what testimony.
All right.
Right. So that's what you do. You like I said, you get your notepad, you just take down the information that she's saying that's wrong. And it also gives you an opportunity to develop a cogent argument, guys. It's actually better. Cutting people off. Oh, she's not allowed to say that. She can't do that while she's trying to get her thoughts out. All it's going to do is make the judge and her and everybody just hate you. And it's not going to achieve the ultimate purpose, which is winning. Winning, as Charlie Sheen would say. And it also makes you look more judicious and more like you know what you're doing. and it builds credibility, and credibility is everything when you're a non-attorney. When they see that you know what you're doing, you take away about 99% of their artillery. I'm just telling you guys from my personal experiences remember, I am a guy who tried many pro per cases myself before I was a lawyer. I'm a guy who was locked up, beat up by a cop because I asked him for a copy of his ID and he didn't like that. So, I'm on your side, but I want you to win. That's all I want. I just want you guys to win. Don't you get it? Like, I'm not here to try to take sides. I'm here to make you better. If this is the goal that you have, don't go into court. I never had anybody to teach me. Nobody took the time to teach me this. So, take it with a grain of salt, but if you're wise, you'll listen to what I'm saying.
Well, I will listen to motions.
I get it. Go ahead.
Your Honor, Mr. Meyers' harassment has become increasingly worse since I filed and received the protection order petition. So
That's
I believe
nothing
that
to do with
those
the petition.
additional contacts
Oh,
are,
don't interrupt her.
I believe those additional contacts are relevant to
Then
whether the
amend-
current protection order should be in
He
place.
is actually right there. If you're going to raise additional issues.
Can I
If you
move
believe
to
that-
amend the protection order petition to include additional harassing
You have
contacts?
to do that ahead of time.
Do you wish to do that?
I move to amend the petition to include additional harassing contacts and to request expanded scope of the protective order.
Okay, I think we're going to have to file an amendment.
Okay.
And then we'll.
So why did she bring us here? This is,
Sir,
He's pissing off the court.
just try to restrain yourself for a moment.
Self-defeating,
You know, he's asking-
self-defeating, guys.
You do need to ask for that. If you want to ask for additional relief and ask for include additional acts, then he is in fact entitled to have notice of that and to respond accordingly. So you need to go to, she has a form that you can fill out. We will continue this hearing.
you can't continue without hearing these incidents here. We're here. She can file an amended complaint after this. You can't stop the hearing in the middle of it and amend it. You can't, she needed to, this is all in the court rules. If you want to file an amendment, you need to do it ahead of time, not
That's
come in-
true.
You cannot do it halfway through the hearing. This is a
Okay,
tactic.
that's
She
fine.
cannot do that. You have.
That would be true in California for sure. I don't know what the rules are in Arizona, but I'm impressed by this guy, despite the fact that he keeps interrupting and he's going outside how I would behave in court. He's not a lawyer. He knows his stuff, guys. I'm not gonna bash him. I mean, he really does know his stuff. Now I believe she's trying to get two bites at the same apple. I think that if she does move to amend, that the court would be within his rights to deny the amendment because she needed to have been prepared. When she filed her original complaint, she should have sought leave to amend when he filed his reply brief or his opposition brief. In her reply, she could have included additional information or simply moved to amend. And that didn't happen here. So to me, it looks like she's caught off guard. She doesn't realize in advance that this guy knows his stuff. And if in fact she got his wife fired, if he's anything like me, I mean, hell's going to freeze over before he stops fighting. That's just the way it is, man. You don't mess with a man's wife. That's just how it is, guys. I'm just being honest with you. If that's what happened, I don't know all the facts yet. I want you guys to share them with me, but based upon his demeanor, that's what it looks like is what happened here.
To hear this out. This is my day to be heard. This has already been continued once. In the interest of justice, I have the opportunity to be heard on these matters, and you cannot keep continuing them. Once the hearing starts, the rules are clear. Once the hearing starts, there's no continuing. That's why it had to get continued before the hearing last week. Once the hearing starts, there's no continuing. So we need to continue with this hearing. She was not prepared. That is not something the court can save her from. You're not her attorney, sir. You're the referee. She needs to testify to these statements under oath, and you need to see if these petitions, the matters that are directly on the petition constitute an injunction for harassment, and you need to either uphold it, modify it, or dismiss it today, right now. There is no grounds, no legal grounds for you to issue a continuance halfway through the hearing because the plaintiff didn't get her way. That is absolutely not what happens in these hearings at any point in any time, and it will not happen
Right.
in Meyers.
Thank you. You wish to address that, Mr. Chairman?
If If it's appropriate, I'm happy to testify to the content of the existing petition and
Okay.
then move to
We'll
amend.
proceed that way. I believe he may be correct in terms of the amendment issue.
Yeah, I mean, the judge is
So on
judge is
September
following the
12th,
law.
he called my
Doesn't
cell
blame.
phone, began explaining he was being criminally prosecuted for disrupting.
Now, let me give you the opposite. Typically, you're going to get a mealy-mouthed, like total pussy wimp who's going to go into court as a pro per, and he's going to get steamrolled by opposing counsel and the judge working in tandem. According to many, because I could never say that because I'm an officer of the court, but according to many other people, that's what typically would happen, because I certainly couldn't say that, right? Because I could get in trouble. But according to other people that I've heard, that's exactly what happens, okay? This, if you can read between the lines. And in this case, although you can sit here and trash Lane and try to put him down, like I'm sure like the dickbag guys will try to do, you know, there's two speeds with most people who aren't trained lawyers. It's going to be hardcore or it's going to be wimp, okay? So all I can do is, you know, if I was in a judo match, I would give him an ippon. I think that he's winning. And the fact that he's a pro per litigant is working in his favor. And if you look at above here where it says delete laws, I made some mistakes. I now realize the judge can and will throw you in a cage. That's right, Chili. And that's all I've been trying to tell people. Like, I know a lot of people hate me. Oh, you're just a bar guy, whatever. You're just part of the system. Guys, I'm trying to keep you out of jail. Do you think I liked visiting Chili in jail? Like, you know, I got a family, you know, I got kids, like going down to the court and then getting harassed by the deputies, then ultimately being harassed and given a third degree by the head bailiff, the head deputy of that jail, and being told I can no longer see my client because a bunch of frauditor people lodged complaints with the judge. And apparently the judge contacted the jail and forbade me from seeing him because I'm an out-of-state attorney. How do you think that made me feel? Right? Think about that. But I felt I had no choice because nobody else had the right to make personal visits, as far as I know. And if you guys have ever been locked up, outside contact, or like be in the Marine Corps, like boot camp, just getting a piece of mail that smelled like perfume from your girlfriend, like that makes your whole month, man. Like just that. So like me knowing that, I just felt like, man, I got to go and like show some support to this guy. But do you think I wanted to do that? Of course not. I got a lot of shit on my plate. But I'm just telling you, when you get locked up, you're putting your whole family, your work, your friends, your clients, everyone is affected. So all I'm trying to do is teach you guys, don't get locked up. Do the things that I'm trying to show you how to do if you're going to be pro per to avoid getting locked up. And make sure you hire an alpha male lawyer if you're not going to represent yourself, who won't let you take charge of your case. Don't ever hire a lawyer that you think that you can control, because you're going to lose your case every time. I'm just telling you, that's just how it is. But let's keep going.
City council meeting, so that I am the
She already
acting
talked about
justice
September
person.
12th. We were moving it. She started September. She just testified 2 minutes ago, sir, that she, September 12th, access to justice, go with what's on the paper. Then she started to talk about October 2nd. I wouldn't have let her. We got into the little thing
appreciate
about
that,
the
Joey.
amendment.
It doesn't
Now
feel
we're on
that way.
October 4th. Talk about October 4th. You already talked about.
Sir, you don't get to run the hearing. Do you understand that? Do you actually understand that?
I do when there's a judge that's running the hearing.
Okay, that's cool.
I just have to make sure this is all on the record because you're
It is on the
obviously.
record.
No, I have to state.
Oh my gosh. So I got to just point this out. Chili just said they banned perfume letters. I mean, guys, in my opinion, that's cruel and unusual punishment. I don't know how many of you guys have been to jail or been in the military, like boot camp, but a perfume letter, again, it's just getting a piece of mail, like from somebody who cares about you when you're like suffering is, I can't even explain how that feels. It almost makes me want to start breaking down emotionally because I know what it feels like. And it's, why Chili, what the hell? Why would they ban perfume in letters? That's cruel and unusual. Give me a bunch of ones if you guys think it's cruel and unusual punishment to ban perfume in letters. That just makes me sick to my stomach.
This that you're not that she's again
Terrible.
trying to talk about something that we've already moved on from.
Well, apparently we haven't moved on.
You don't get to go in reverse. We'll be here for the next 2 weeks then.
Okay, I get to go in reverse if I want to. Cite me some case law on that one.
On what?
I don't get to go in reverse.
It's procedure, it's not case law.
Okay, send me the procedure.
You want me to give me,
No, that's okay. Go ahead. You
don't
go
play
back.
with me, sir, because I'll pull it out right now. I'll be on
Okay,
Westlaw while she's talking.
Cool.
So a statement like that, like most judges would immediately throw you into contempt for making statements like that. I want you guys to understand something. Don't think that this is a roadmap as to how you can handle things in court. There's some other dynamics going on in here that you don't know about. Okay. Don't think that you guys can behave like that and get away with it. Most judges will throw you in jail. And if you don't have enormous financial resources, you'll stay there.
Go ahead, back to September. You want to elaborate on September 12th?
Just to close out what's stated in the petition, which is that the phone call ended with Mr. Myers.
But hold on,
saying-
she already stated, sir, what was in there. She said she was going to go with what was in the petition.
Okay, I'm asking.
I'm about to read from the
She's
petition.
gonna read it. Oh, let's do that.
So we're going in circles.
He ended the call by saying, one of two things is going to happen. Either you are going to help me or I am going to expose everyone.
Sounds really
Sir.
threatening.
So
It's right here.
I don't care what it is. Don't quit commenting on the testimony.
That's a problem.
You say you understand the rules.
I
You understand the
do.
law.
Do you?
Yes, sir, I do. And does that
Teetering on
mean you should
contempt.
comment on the testimony as-
No, it doesn't. I'm not allowed to do that, and I'm being rude and interrupting. I'm
Okay.
sorry. I'm trying to do my best to
Okay,
keep it under control.
All right, go ahead. Christine.
I believe that a reasonable person in my position receiving a phone call that ends with the statement, either you're going to help me or I'm going to expose everyone, would be alarmed, annoyed, or harassed. And in fact, I was alarmed, annoyed, and harassed by that phone call.
Okay.
On October 4th, I received another phone call from Lane Meyers. I answered not knowing who it was. And when I said hello, he said, hey, Stacy, I'm going to give you one chance to explain yourself before I file this lawsuit against you. Why did you call Judge Zips and get my wife fired from her job? I said, who is this? Lane said, you know exactly who this is. This is
Oof.
Lane Meyers. I know what you did. I know you called Judge Myers and got my wife
Judge
fired from
Zips.
her job. I know why you called Judge Zips.
Okay. So guys, you heard that, right? So he believes that this woman got his wife fired from her job. So here's what I believe. I believe that the judge sees more evidence and knows more about this case than we do. And I think that that's why the judge is giving him deference. If this is true, I think honestly, for a non-lawyer, I'm being the judge right now. I'm giving him a pass. I'm just telling you, like all of the craziness and the violations of procedural rules, not letting people finish, cutting off the judge. As a human being, I'm giving him a pass. I'm just telling you me personally, because I don't think that we have to be like pro forma. I believe that we have to judge everybody on a case-by-case basis. Everyone's different. We're all unique. God created us all to be unique. If we were all drones and all the same, what a boring place the world would be. Give me a bunch of ones if you understand what I'm talking about.
And got my wife fired from her job at federal court. I said that information is incorrect. This phone call is harassment. Do not call this number again. And I hung up. Lane then sent me a series of text messages stating if it's not true, you would have made a statement for the record and not hung up, along with a link to.
By the way, failure to deny an allegation is a matter of law is deemed an admission. Remember that, guys. Failure to deny is an admission. And so if he is as learned in the law as I think he is, he probably knows that. And that's why he said that to her. Just an interesting tidbit for you guys to understand. If you don't deny something, that means it's an admission as a general rule. Remember that. That comes from ancient common law. Let's keep going.
To Arizona's harassment statute. I have no contact with Mr. Wire. Mr.
You notice how
Myers'
she left out? Sir,
wife.
she needs to read it. She's going to read from the paper. You can't skip words.
And I have not at any time communicated with anyone at federal court about her employment. This call in combination with a call on the 12th, I think both calls would cause a reasonable person to be alarmed, annoyed, harassed. I, in fact, was alarmed, annoyed, and harassed. And I believe that the call on the 4th was demonstrating an increasing level of intimidation by Mr. Myers, at which point I filed for the injunction against harassment.
Right, do you have anything else on there?
Not at this time.
All right,
She needs to present her exhibits.
do you have any exhibits? you wanna present?
Stomper, tisk, tisk.
She should have already given them to me before the hearing started also.
by law. I turned mine in weeks ago.
I haven't received any exhibits from Mr.
Of
Meyers.
course, I turned them in digitals.
I literally received them this morning on the computer. If they weren't from the computer, they were still on the digital computer. No one received notice.
Notice of what?
That they would be on the computer. So last hearing before it was continued, they were on the computer.
Right, yeah, like I turned them in before the last
Yeah,
hearing.
no one
Okay, I didn't know-
knows
I didn't
until
know
the day of the hearing.
Right, okay. But all I'm saying is, okay, so now she did her testimony, right? Now, does she have any evidence to support these allegations that she wants to turn in?
Okay,
That's what I'm saying.
okay. I'm gonna ask
Before you move to me.
In other words, she was lawfully served, if I've got this right, with this information, and she had the right to dispute it or refute it. But apparently she didn't look on the court website. And this is a typical rookie move for a non-practicing attorney. And I don't know of any law professors who are actually practicing attorneys, right? And maybe she was a practicing attorney before the courts went digital. I'm just telling you, I'm thinking like out of the box because there was a time when like a couple of year period where I wasn't litigating at all. I was just settling cases. I was just signing up cases, settling, not litigating, referring all my stuff out to guys like Alan Beck to litigate. And I didn't know there was a rule change. And so I sent one of my runners to go and hand file a doc, and it got bounced. And they said, the rules of court changed like 6 months ago, dude. Didn't you get the freaking memo? So there's a high probability that she doesn't even know that all this stuff is being electronically filed. So that's what I think is going on. I'm trying to read the, what do they call it? The tea leaves right now. So I don't know 100%. Look, I would love to have Lane come on and tell me more. I'd like to get more of his side of the story. I think the dude is, he's on fire, man. He reminds me of like a prophet. I just would like to teach him better decorum, because I think he would have a better shot at winning and a lower probability of getting locked up. That's all. That's just me. Like, everybody understands something. I'm not here to put the dude down or insult him. That's not my style. My style is I can see some issues here, and I would like to make him better at what he does. So Lane, don't ever take anything that I'm doing as an insult. I want to make you a better person, especially if what happened to you is true. If this woman did get your wife fired, you have a strong ally with me. I'm still a jarhead, man. Somebody did that to my wife. Oh man, trust me, you wouldn't be the last time you heard of Michael Eli. Let's keep going.
Well, I asked you a question.
Thank you.
Your Honor, I did submit a number of YouTube videos
Thanks,
made
Julie.
by
I
Mr.
appreciate
Meyers,
that.
which include comments about me, but my understanding is those would not be admissible today if the issue before the court is limited to the current protection order.
So is it my turn? So talking to you, is that her saying she is not presenting a recording of either of these phone calls?
Are you representing?
I'm not in possession of recording of. my
Okay,
phone
well,
call.
so is it my turn now?
I do have a copy of the text message that Mr. Meyers sent. I have copies of emails I've received from other people related to Lane Myers.
Not relevant.
Text message
So-
would be relevant.
No, that is. I'm talking about the emails. The text message is in my exhibits, is what I'm saying. The text message that she's talking about.
Hey, Steve, good seeing you, buddy.
Again, Your Honor, I think that his conduct on YouTube and the conduct of his
YouTube is not
Okay,
mentioned in
followers,
this petition?
Hey.
Petition?
Hey.
He's got to mellow out,
As
man. He's
well
got to
as
let her
his
talk.
conduct in the courtroom
Remember that thing
today.
about- Remember that thing about not interrupting?
Again, all I got to tell you guys, get out your notepad, point by point, write down everything that she's saying that you disagree with. You'll have way more power and way more sway with the judge. The judge already in his mind knows probably 90% of the stuff she's saying is crap. All right. I'm just telling you, if the judge has any experience, and already he's winning. The judge is I'm telling you, based on the facts of this case, this judge is probably already favoring him and he doesn't even know it, just based on my tea leaf reading. I'm just telling you guys, that's how I feel about it. You might have a totally different perspective, but I know how to read courts pretty well.
Okay, go ahead.
It is my position that the YouTube videos and his conduct in the emails
Well,
I've
thank you,
received from people
Tiffany.
who watch him and his conduct in the courtroom today are all relevant to the
By the way, guys, I'm not watching the screen the whole time. Thank you so much, Tiffany. Tiffany is one of my newer members. I think I just made her think I just made her a moderator. She's super legit. I think she's a single mom, and she just really cares about her kids, and like she's just a really legit lady. I recommend you guys all like and subscribe to her channel. I know she supports the Marine Corps too, so she's got a special place in my heart because you guys know that Marines get treated like dog trash when they're in and when they're out. So give me a bunch of ones for Tiffany, guys.
Level of harassment I am experiencing because of Mr. Myers. At a minimum, I'd like to admit,
YouTube things occur.
beginning October 2nd, extending
Unless she's gonna enter evidence, this is hearsay.
One hearsay is admissible.
But she's not moving to admit.
She's answering a question. Okay? When were they?
The first one that I'm aware of occurred on October 2nd, and there were additional videos as recently as last week.
And you did not include those in your petition on October 2nd.
I have not included any YouTube videos in my
I
petition.
believe
That's a
Mr.
problem.
Myers is correct. It's a matter of law. And in the case that there's a case that hearing is limited to matters that are actually presented.
That's right.
That's like 4 or 5 years ago. I can't remember.
The case is limited to the matters that you presented. And again, he provided his evidence. She had a right to object to his evidence. So typically when someone provides evidence in a case like a summary judgment motion that I will be opposing, I will do an opposition and then I'll do objections to evidence, objection, relevance, objection, hearsay, and I'll include a statement of case law behind each objection. I mean, it's a lot of work, guys. That's why I don't like filing lawsuits, because a lawsuit will consume you, especially if you believe in your client. That's why I always, always, always want to take my case away from the black robe taskmaster. I want to front load my case and win without having to have it go before a judge. That's just something that you guys need to understand about me. Like, don't be bringing me your cases after you destroyed it and then try to tell me how to litigate your case. Don't do it. I mean, if you want my help, get me at the very beginning and I'll show you how not to destroy your chances of winning. If you want to go out and do police auditing, talk to me first so I can explain to you how to deal with cops so you don't get arrested. Because once you get arrested, now your family and your friends and everyone, your dog, everyone's going to be deprived of you. Who does that help? Tell me, who does it help? Even if you win, who does it help after you have PTSD? And everybody around you who cares about you is sacrificing to make sure you're okay. I want you guys to think about that. That's something you need to think about if you're going to go out there and do this. If you're going to do the Lord's work, you need to be godly about how you do it.
Then at this point, all I would have to admit would be the copies of the text messages.
Okay.
I do not object.
There's no objection.
The text messages on October 12th, October 4th, right?
Hold on a second.
That's what I'm saying. It says that there's a text message on October 4th.
Amen, Salt Shaker.
There was one. They see the on here.
Thank you.
So this, I don't see a date on this, right? So this is the one you're referring to?
That's September. That's the one. That's the text message referred to in the petition, sir. I'm going to be entering the same thing and it'll have the date and all that
So this will
too.
be admitted into evidence.
Yep.
Without objection. All right, go ahead.
Okay, so that was interesting. So normally you would have to delineate each exhibit, exhibit 1, exhibit 2, and they have to be dated. So I just want to show you why I think the judge is giving him great deference. Listen to what the judge just did. The judge knew it wasn't admissible because it wasn't dated, but he got testimony from the deponent and he said, without objection, really quickly. And she is clearly an inexperienced attorney. Just because she has a bar card doesn't mean she's a good lawyer, guys. I know plenty of lawyers who've been in practice 30 years and they've never stepped foot in a courtroom. I got all my experience litigating, and I did 3 trials before I was even a lawyer as a certified law student. I know how judges think. I'm telling you right now, Lane, dude, back off on this judge, brother. I mean, this guy, I feel that there's something going on here, and I don't think you're catching it because you're pissed off because of what happened to your wife. And I love you for that. But at the same time, that's why, man, if I was an Arizona lawyer, I would be representing you pro per right now. Unfortunately, I'm not pro per, pro bono. But I just want you to know, because when you mess with a man's wife, you're messing with every man's wife. So it's a totally different situation with me. If I want to know more about your case, I want to know what she did, but based upon the way the judge is leaning, I think that there's a lot of evidence in your favor, brother. Let's keep on listening and see what you guys think.
Me?
Yeah.
So am I attacking her evidence now? Because I already did my opening statement, you know?
Testify.
All right. I already no, it's my, right, not my opening statement. All right, so we're gonna start by the plaintiff herself just said in open court on the record forever that I contacted her. We should admit my evidence first.
Oh. What does he actually have?
I have the recording of the phone. I have my evidence is this recording right here. See how she says I called?
Okay.
And this that she called, and it's a digital copy of the text.
Are they both calls or just one call?
Both. And that ain't working. I got this too.
Hey, Misty, good seeing you.
Admission of the recordings?
No, Your Honor.
Okay.
I mean, they're the calls that got me an injunction.
She's not.
So now they're not going to be we're going to hear the whole call now, not the paraphrasing of it to fit her agenda.
Hey, Kevin, good seeing you, brother.
Do you have something?
Yeah. So how do we? So should that's what I'm trying to say is like, if you got my things, I want to play my thing and then use my evidence to counter her testimony.
Do you have that USB drive, Mr. Meyers?
Yeah, right here.
Thank you.
Sorry to hear that, Misty.
On the big screen there.
Do I move the mouse or you move it or what?
I'll move it.
Guys, everybody welcome Misty to my channel. Misty, I don't tolerate a dude raising his hand to a woman. That's just, God made men stronger for a reason, so we could provide and protect, so you could give the love and affection that our children need. Somebody should tell Gavin Newsom that. But I'm glad to have you here, Misty. I really love it when I get women on my channel because I'm like a 90% male channel, and the message that I have is for all Americans, not just for the dudes.
And she said that my behavior in court today should affect your ruling. Well, what about her buddy right here? That should affect the ruling too.
Is he a party?
He is. So let's go to. Oh, this is for the next case. All these lies. Let's see.
Sir,
let's go to
strike that whenever record exists.
Hold on one sec. Ding, 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 ding. Thank you, Donnell, for supporting my channel. I'll make sure that my daughter and my wife know that you're supporting my channel. By the way, guys, my daughter is homeschooled and she's helping me with my channel, and I'm trying to teach her how to be an entrepreneur so she doesn't have to rely on someone to take care of her, right? And hopefully she'll become a lawyer and she can take over the firm someday. But give me a bunch of ones for my daughter for helping me with the channel. And she made a mistake and listed all of my members as Lance Corporals, even though they have PFC chevrons. So I'll have her fix that. But don't hold it against her. She's doing her best.
All right, let's see.
Do you want me to scroll up or down?
The calls are under go to perjury. See the file of perjury? Click on that. There you go. Stacy Jane, call 1 right here. Play that. This is the call on September 12th. Hello, can I speak to Stacy Butler, please?
This is Stacy Jane. My former name is Stacy Butler.
All right. Cool. Well, congratulations. I don't know if that's in reverse or going forward. You got a new name, but my name is Catherine Hendricks, is my girlfriend, and we spoke by email a year or two ago, about 2 years ago. So you're the access to justice person, right?
I am, and I do remember that email. I'm actually on the other line on a work call. I just wasn't sure what this number was.
Oh, my bad. I got it's the listed number for you. I'm sorry.
Yeah, that's okay.
So yeah, I need some access to justice and that I wanted to talk to you about for some stuff that's going on in Tucson right now.
Okay, could you just send me an email? Actually, I'm in the car and on a work call.
Absolutely, no worries. Absolutely.
Do you have my email address?
Do you want me to use the same one? Let's see, this is Stacy Butler at Arizona.edu.
Yeah, it's actually Stacy Jane now, but Stacy Butler on the website.
Okay, so how do you spell the
Right on, dude. We'll talk about it later, Life Thunder. Right on, dude. Congratulations.
So I got arrested at the council meeting for booing. I know this is gonna probably something you're not
He's 13 though.
because these are probably a bunch of your friends, but my wife also went there too, so it's a long story.
So
But
cool.
I'm fighting the city of Tucson for booing during the city council. I'm charged with 3 charges, and so like this is access to justice stuff where like I'm doing it pro se. I could get a lawyer, but I want to show the whole community how the law works and our rights, and like it's a whole thing where like you guys work with literally the Pima County Prosecutor's Office. So I'm either gonna get help from you or I'm gonna expose the ironic hypocrisy that goes on down there. It's one or the other.
Okay, yeah, if you can send me an email list, just so we can keep this on my radar.
All right.
All right, thanks. Bye.
Okay, so basically what it sounds like is she's trying to argue that that is extortion or blackmail. But if you listen to what he said is, I'm either going to get help from you or I'm going to expose the corruption of what's going on down there myself. And so typically extortion would be, I'm going to expose your illegal conduct, like you're having sex with a neighbor's dog, for example, right? I mean, because I can't think of anything else that's crazy. That would be illegal at the same time, because that would be clearly illegal. Or I'm going to expose you. But look, this dude, I mean, he's married to a woman, whether it's common law or regular marriage, who works for a federal judge. I mean, he's no slouch. He's obviously highly intelligent. He has probably an IQ, I would put in the based on just watching him, I would say within the 120 to 140 range. And he has a really high processing speed. And this is something that I've been able to gauge after years and years and years of practicing law. The guy he's in the genius IQ range. The issue is like most geniuses, he is, like my dad. What do they call those guys? There's a name for it, but like artists and stuff like that. Somebody put it in the sidebar. Oh man, I'll think of it in a minute. But typically people that are really, really smart, they I feel like I'm playing charades right now, but they also have like this, like a quirky personality that makes it really difficult for most people to relate to them. And that's just it's Thomas Aquinas called it an accident. Like, a beautiful woman, it's an accident because she relies on her beauty. And when she's no longer attractive, she's broke and has no one to look after her. There's a word for it, but I'll think of it in a minute if you guys don't give me in the sidebar. But like eccentric, he's an eccentric, and I'm an eccentric, and so is Chili, classical eccentrics. But the point that I'm trying to make is that the guy knows what he's doing. Let's keep going because I don't want to bore you guys too much.
Mr. Meyers, was that the text that you referred to
Which one?
in that phone call? The one that you objected to from
The one we just listened to.
Idiots.
No, in that phone call, you referenced that you sent her a text 2 years before.
Email. That's the email that she
Eccentric.
right there.
And that's the one you objected to.
That's the only contact I've ever had with that
Okay,
woman.
well, actually, since you actually. brought it up
Eccentric. That's
yourself,
right. What's the matter, you? Yeah.
So maybe we can.
Okay, cool. That'll even benefit me.
Okay.
I believe that, but if
Alright.
you can't use it for the injunction because it's outside 2 years.
Well,
It doesn't matter if you contacted somebody 5 million times. There's people that get these against their wife that they've been in a relationship with
Sure.
25 years. It doesn't
I've
matter.
actually done these things before.
I hope you have done these before.
Sir, could you stand someplace else?
Oh, my bad. I thought you were asking me. So that was September.
Yeah, I was just asking if that was that the one that's.
So that was September 12th. And as we just heard in her testimony now on the record a few minutes ago, and in the call, she said that I called about access to justice. Okay. And if you notice, when she referred to the second call, which we'll get to in a second, she indicated that during that call, she said this and the second call, not this call. Nobody just heard this.
Wait. I'm confused.
I'm making a point here.
I know you're making a point, but I'm confused.
Right,
It's your
right.
factual point.
I'm getting there. All right, so I'll start over with it, to be clear. So we just listened to that phone call.
Yes.
At no point did that person say, you're harassing me, or any of that. In fact, she said, let me know what's happening. Here's how you can get a hold of me. Keep me in touch.
No,
I'll see what I
no,
can
it's
do.
not.
Okay. In the next call that is on here, it's testified in court and wrote on this paper, and we'll hear on the call where she said, this call is harassment. Okay. Well, we can clearly hear that this woman knows how to say this is harassment and this is
keep calling me and I'll see what I can do to help you. Okay. So I want to make a point right now. We just heard this call and multiple
Thanks,
times
Clint. That's what I meant. Yeah.
that she's using and calling this is harassment. She encouraged Mr. Meyers to contact her again in regards to the access to justice issues that he called and started the phone call.
I heard the testimony.
You heard it. You heard the call. You heard her testimony.
Well, Clint, I see your comment. So Clint says eccentric isn't what comes to mind when I think of Chilean Lane. So obviously Clint is one of these guys who hates us, but eccentric is what comes to mind to me. Yeah, they're eccentrics, and I'm an eccentric as well, and so is my father. My father was a impressionist artist, and he was a home builder, and he was a combat Marine. He was just rattled from the war. He had PTSD. I mean, it's all there. All the commonalities are there. But Clint, you're entitled to your own opinion, but I don't know if my moderators are going to let you stick around here much longer because you're kind of a dick. But other than that, let's keep on watching the video.
Now you heard the call where she left out key parts where she said either you're going in her testimony on paper, which I believe could be getting close to perjury now, is that one of two things is going to happen.
I'm going to start the
I get what you're saying. All right. It's fair. That's fair. I'm not accusing you of it. I'm saying this is where we start getting off track. One of two things is going to happen. Either you're going to help me or you're going to expose everyone. But the call didn't say that. That's not what it said, did it? The call said, can you go back towards the end there? About right? Yeah.
Right there?
Yeah.
I'm doing it pro se. I could get a lawyer, but I want to show the whole community how the law works and our rights, and like it's
Semper Fi, homie.
the whole thing where like you guys work with literally the Pima County Prosecutor's Office. So I'm either gonna get help from you or I'm gonna expose the ironic hypocrisy that goes on down there. It's one or the other.
Thank you. So I said I'm going to expose the ironic hypocrisy that goes on down there.
Yeah,
I did not say either you're going to help me.
that's not blackmail or extortion under any definition that I've ever heard. So I agree with Lane on that one.
I'm not bad. I did not say one of two things is going to happen. Either you're going to help me or I'm going to expose everyone. I said either you're going to help me or either if you can't help me, we can hear. I didn't put an ultimatum to this person. I said, or I'm going to expose the hypocrisy down there. Down there.
I got the testimony.
That's not related to a person.
This is testimony.
I get what you're saying. Right. So I'm saying, that's not saying you need to do this or this is going to happen to you or this person. This is, I'm going to expose the hypocrisy down there. Okay. So we can see that her testimony on the paper to get the injunction is not clear and consistent with what was actually in the phone call, because the actual phone call, this is just a paraphrasing of it that I believe if we took this as a straight transcript, word for word, in a sense, this transcript, her transcription of the events.
Wait, did he say trans? Uh-oh. I hope my channel doesn't get banned. Yeah, zoink, scoop.
Into this little box does not match up with the words that we would hear, for example, in a transcription word for word. I believe she changed some of the words in this petition right here, as the video just showed. I said I was going to expose down there, as in the school and the relationships and social access to justice, all that. And that she says it's harassment, but she also immediately admitted that it was for a legitimate reason. Access to
right,
justice.
lawyer
During
dog.
the call, she said, "Call me back, and you have a legitimate reason to contact me again because I want to know what happens with this." At the end of that call, she did not say this is harassment or don't call me. Okay, so now moving on to the next one. So September 12th, that happens. 4 hours later, my wife gets fired from her job as a law clerk for Judge Angie Martinez at the federal court. 4 hours later.
Is that relevant to this?
Absolutely, because she's saying in this next one, right? She's saying that I had nothing to do with your wife getting fired. Okay, so now we're gonna get into it.
Well, why don't we get to the call first? I think you're putting the cart before the horse.
Well, I mean, I want to talk about her paper testimony before, so I want to bring up some points she made in her paper testimony.
Okay, go ahead.
She said she received a phone call not knowing who it was. Okay, I said I'm going to give you a chance to explain yourself about that, because before
Where are we at?
right here,
What are we talking about?
right there,
September, you're
no,
talking
the
about?
top one, the first, the highest one.
October 4th.
Yes.
Okay, go ahead.
So October 4th. Now, mind you, she attempted to introduce in here about my YouTube videos and stuff, However, what she fails to mention is on October 4th, I called her and said, as we'll hear, before I make accusations against you and put them on YouTube, I'm going to give you a chance to speak for yourself. That's called being a polite human, not just defaming her. So, okay, so now on the
Right, but this isn't a defamation hearing anyways. It's basically a hearing that she feels she's being harassed, and she's trying to introduce statements that she believes are harassing or statements that, you know, could cause her harm. And so far, I haven't heard anything.
the legitimate purpose under Arizona, this harassment thing, my legitimate purpose on October 4th was to call her before I put a new, because I'm a news reporter, I have a news company in the state of Arizona, and I'm a media outlet. So before I put a recording, I mean, before I put statements out accusing her of having something to do with it, I gave her a chance to speak for herself. I said, hey, I'm about to make these accusations against you. Do you want to speak for yourself first? Okay. She, as you can see, she immediately said, this is harassment. Do not call this number again. Okay. That was on 10/4. So at that moment, I thought, okay, well, since this was a legitimate purpose to call her, whether she was a public employee or not, because I'm calling to ask her this specific question. Now, if I called her 25 times a day saying, hey, it was you. No. One call. Did you have anything to do with this? You think?
So one point that I can throw at him is that he has absolutely no fear of the courtroom, and he is acting as if he's just one of the boys. And so he's not scared about the seal of the court or any of that stuff. And it's really interesting. So what I'm going to share with you guys really quick before we move on, because I don't know how much long we may have to roll this over into another episode, because we've already been going for almost like 2 hours and 6 minutes already. But I want to share with you, and I've shared this, I think, with people like Chili and stuff in the past. I'm going to drop you guys. Thank you, Danelle, and all you guys for supporting my channel, by the way. I'm just seeing like the things start to scroll, because like I can't constantly look at the sidebar. So it's like scrolling super fast, and I'm seeing people are giving me super chats and all that. And I really appreciate that, guys. It really means a lot to me. I know that $10 to some of you is like $300 to other people, you know, who have money. So it means a lot to me. But if you take a look here, so Balistreri versus Pacifica Police Department. This is a case that I memorized by heart when I was younger. And that's another thing that's really cool about guys like me and Chili, and I think probably Lane, is that we have almost like a near photographic memory. And so if something has an emotional impact on us, we're able to memorize it. And so this is a case that I've always carried with me, and I can spit it out like that. So basically, it's a significant case involving a pro se litigant, Jenna Balistreri. She filed a 1983 complaint against the Pacifica Police Department and its chief, and she alleged violations of her constitutional rights due to inadequate response to her reports of domestic violence and harassment. The case basically, you know, kind of just, it sort of shows you, and by the way, in federal court, they call them pro se litigants, just so you guys understand. Oh, right on. Thank you, What's the Matter You? Thank you, brother. Guys, What's the Matter You is one of these guys who, like, we don't see eye to eye politically on a lot of stuff, but we agree on natural law, and we agree on basic tenets of honor and civility, I think. And he's always supported my channel. Whereas some people just, if I disagree with them on like one little thing, they'll hate me and trash talk me. But I always try to let you guys know that, look, I don't want you guys to agree with me about everything. I just want to be able to have a based, civil sort of conversation with you. So please make sure to like and subscribe to What's the Matter You. Super legit dude. He is also one of Chili's loyal people. I got to tell you, you know, like all you guys, I really appreciate you supporting Chili and stuff, and helping him out when he was locked up. And we really saw we all find out about who our real friends are when we're locked up, and people go along with the majority deal. Oh, stay away from that person. You find out who your real friends are when you face adverse circumstances. So thank you, What's the Matter You, for supporting me as well as Chili. You're an awesome dude. So the case highlights basically the challenges faced by pro se litigants, especially with civil rights cases. And in this case, it's not a civil rights case. It's not a federal case. This is a Ninth Circuit case, but it's sort of adhered to by other circuits, not just the Ninth, and state courts. And if you were to shepherdize Balistreri, I'm sure you'll find Arizona. I don't have the time right now, guys, because I have a day job, but I'm sure you'll find that the Arizona courts have a similar scheme, a similar judicial scheme when it comes to pro se or pro per litigants. But the bottom line is Balistreri's complaint was just dismissed ad hoc because she had made some procedural mistakes. And procedure would be like, well, one of the mistakes would be like not filing, something or speaking out of hand, not letting the other party finish, right? But it depends on your judge. You could have a hard ass judge. This judge obviously is not a hard ass. Otherwise, Lane would already be locked up for contempt based upon the way he's talking. But I think the judge recognizes what's going on, as I've said earlier. But what happened is the case got dismissed, and the Ninth Circuit said pro se litigants shall not be denied a fair hearing on the merits of their claim due to the ignorance of technical or procedural requirements. That's literally what I remember from like 1991 or 1992. And it's still emblazoned into my brain. And that's why, like, when I see guys like Chile and I see guys like Lane, Chile obviously was denied a fair hearing, but he wasn't pro se. See, he wasn't pro per. He had a lawyer, and many people say the lawyer he had was, not the best. I don't know. I don't know the guy. I'm not a Nevada attorney. I practice law in California and Texas. Now, the Ninth Circuit reversed Balistreri, and the court recognized that pro se pleadings should be liberally construed, particularly in civil rights cases, to ensure that litigants don't lose their right to the hearing and due to the ignorance of technical or procedural requirements. And so basically, pro se litigants can make a lot of mistakes, all right? And Lane's making quite a few, in my opinion. Now, Lane, you may disagree with me, but don't hate me, because I'm not saying, look, man, iron sharpens iron. You probably have a lot of things you could teach me, right? But I'm just telling you, this is my area of expertise. And lack of legal knowledge, pro se litigants often lack formal legal education to understand procedural rules, evidentiary standards like the hearsay rule. Like, I get it. You had objections you could have made that were better than hearsay, but maybe I should do an online evidence course to help you guys. See, the difference between me and the anti-frauditor, whatever you call these guys, is that I'm trying to help educate people so they can stand up for their rights, as opposed to tear people down and insult them and try to make them feel small so I can get clicks or views. I want people to do better so they can take back their unalienable rights that our Creator gave us in the Bill of Rights, under natural law, which is recognized by the Bill of Rights. So typically, they're going to lack formal legal education to understand procedural rules, evidentiary standards, and legal arguments. And so this can lead to mistakes in filing documents, which in this case seems like he actually filed his documents pretty good. It seems like his lawyer is the one who made a lot of procedural errors. Based on the limited information I have about this case, it seems like the other attorney, the opposing counsel, the law professor who's probably never practiced law based upon the mistakes that she's making, she's supposed to be held to a higher standard than him when it comes to civil requirements. And so mistakes in filing or not filing documents would be a procedural mistake. Misinterpretation of laws, failure to meet a crucial deadline without the guidance of an attorney. They might not know how to properly present a case or defend their interests against legal maneuvers by the opposing side. So the typical procedural errors would include not properly serving documents, failing to verify documents. We sign it under penalty of perjury that it's true and accurate to the best of your knowledge. And if it's not to your best of your knowledge, based on information and belief, it's true and accurate under penalty of perjury, in this case, under the laws of the state of Arizona and under the laws of the United States. That's kind of how I would do declaration. These procedural errors can lead to dismissals or defaults, which are often avoidable if you had a lawyer. In this case, if she was your lawyer, it probably would be a legal malpractice lawsuit against her if she didn't file stuff she should have filed, right? Emotional involvement. So the court recognizes this, and Balistreri also, I think, talks about this, is that pro se or pro per litigants are personally involved with their cases. And if this case involved his wife, I think the judge is giving him that. I think the judge realizes, oh my God, like you mess with this dude's wife, right? I mean, he's a human, right? The judge is a human. By the way, give me a bunch of ones also, even if you hate judges or you want to call him a magistrate or rep, whatever you want to call him. I think that this judge is actually a pretty good judge. He's honestly, based on what I know about judges, most judges would have already put him in contempt. So I think that this judge is looking at Balistreri and looking at the totality of the circumstances. Now, judges understand, at least a good judge, that a litigant like this, a pro se, pro per litigant, might become reactive rather than strategic. And obviously he is being reactive. He's not letting the other people speak. He's cutting them off mid-sentence. But the judge is actually being pretty freaking cool. I'm just telling you guys, you can say whatever you want. The judge is being cool by letting him finish and kind of like, dude, stop cutting me off. Like he's pissed, but at the same time, he's like, well, somebody messed with my wife. That's just what I'm thinking. Probably the judge is thinking, man, things would go a lot different if this was me. This is what I believe. This in my heart. That's what, I feel like I'm being told. So they might become reactive and allow the opposing counsel to dictate the pace and direction of the litigation, leading to tactical errors. So that's one thing about Lane. He's not letting her dictate the pace at all. He's controlling the pace. So you can say whatever you want about him. Whatever he lacks in courtroom decorum, proper procedural understanding. I don't know, guys. Give me a bunch of ones if you think that Lane is dictating the pace. Give me a bunch of twos if you think this law professor is dictating the pace of the case. I'd like to see what you guys think, because I think he's dictating the pace, and I think he's been dictating the pace from the very beginning. Bias and intimidation. There's often a perception that's reflected in judicial behavior that pro se litigants are at a disadvantage in court, and this can manifest with less patience in the judge, and can create a strategic exploitation by opposing counsel. And I've seen that happen millions of times, especially men who are in divorce proceedings because their wives basically bankrupted them and they have no ability to afford a lawyer. So they're representing themselves and they get completely railroaded. I've seen it with my own eyes. I'm not going to lie. I've seen it. So I know that that's what happens. So, and then resource constraints. Without the resources and support system, pro se litigants might struggle with their workload, including research, document prep, and understanding case law, which can result in oversights or errors in legal strategy. Obviously, Lane didn't have that problem here. I mean, the guy said, I'll pull it up on Westlaw right now, mother effer. Like he's nailing it, with respect to that. And, some pro per litigants might overestimate their understanding of the law, which I think he's doing to a little bit here. He's overestimating some areas of law, which also can lead to poorly constructed arguments or filings. And others might be too hesitant or intimidated, conversely, to do the same thing and assert their rights. So the Balistreri case is a really, really good case. I recommend that you all take a look at it. Balistreri versus Pacifica. I'm going to drop it in here one more time because it's really, really important. I want you guys to learn. I love the likes and subscribes and the views and all that stuff that you guys are giving me. But if I'm not teaching you, if you're not learning, then I'm failing, because I don't want you guys to hate me. I don't want you to hate anyone. I want you to learn. I want you to understand that I in a way, I feel like divine providence led me here. And if I can help one of you, even if it's in 5 years from now, if you remember this show, that you learned a little bit from me, because trust me, no lawyer is going to teach you any of this stuff ever. You're not going to get anybody who actually sits down here for 2 hours or 3 hours and teaches you stuff. I can go and work on a file right now and make a couple $1,000, but I'm burned out, and this gives me an outlet. So it's helping both of us, because I feel like I'm giving back to the community. And, when you support me, you're giving back to my wife basically, but it gives me the ability to keep going because she doesn't complain as much. And if any of you guys are married for 20 years or more, you understand how that works, right? You get blowback. So this is good stuff for all of us. I'm going to keep going. I have to make a head call, so I'm going to keep playing this, and then I'll get back and we'll talk a little bit more. I think we're about halfway through this video. So we'll probably come back for a part 2. And who knows, maybe I can talk with Lane between now and then. Hopefully he's not thinking that I'm a hater, or hopefully he's, you know, like one of these guys who recognizes that I'm trying to help, and doesn't hold a grudge for me pointing out some of the mistakes that he's made. Because all I'm trying to do is it's like iron sharpening iron. Again, Lane, I'm not even licensed to practice law in your state, but I see that there might be a way that I can help you become a better lawyer and you know, a better servant of others, because that's what this is all about, in my opinion. Is the way you get ahead in life. You can have everything in life that you want if you can help other people get what they want. So let me just really quick. I'm gonna make a quick head call, but I'm gonna keep playing the video. All right, here we go.
You don't want me to call you? I will call you again. Bye. Okay, that was on October 4th. So she says that I then text her the thing, because at that moment, the text, right? The text follows up the call, right? Because at the end of the day, as I said, judicial notice of adjudicated fact, this woman's employed by the state of Arizona, and not liking her name is a legitimate reason to call. I mean, you can't harass her, but people can call state employees and redress. They don't like what's happening.
You're arguing, let's keep to the testimony of the facts first.
I feel you, because I do have race law too.
Well,
so,
that'd be fine.
No, I know. So what this video is going to show is that she paraphrased it again, and all I did was communicate with her that she is a public employee, and therefore this one communication, because the injunction of harassment is designed is
Okay, don't argue. Well, yeah.
a series of acts. Okay, so play it then. Play it.
Yeah, that's probably.
October 4th. Play it. This is the call on October 4th, sir. Hey, Stacey, I want to give you a chance to explain yourself before I file this lawsuit against you. Why'd you call Judge Zips after our phone call?
I'm sorry, who is this?
This is Lane Meyers. You know exactly what you did and who this is and why I'm calling. You called Judge Zips after we spoke and got my wife fired from her job.
That information is incorrect, and this phone call is harassment. Do not call my phone again.
It's not harassment. You're a public employee. That's the call, sir. So in that call, she states that, you know, I asked her who it was. So I clearly I told her why I was calling, who I was, the intention of my call, what I was doing, allowing her a chance to say something before I took action on what I believed to be the circumstances. Okay. I gave her an opportunity to say that wasn't me. But most importantly, even if we took this to the most extreme definition and said that call was harassing, which I don't think it is, and I'm going to showcase all why it was.
By the way, just for you guys who are joining us a little late, the video that we're showing is from another court proceeding. You're hearing audio recording, I think, that he took. And then you're seeing video from another one, because I know that most people are like freaking visual, so they got to see something. But that is actually him. And you can tell by looking at him that he's physically exhausted. I mean, I know how to read people. This guy's tired. And I think what's going on here is he believes that this woman got his woman fired from her job, and he probably hasn't slept in weeks. And so I think that the judge probably recognizes this, and that's why I wanted to discuss the Balistreri versus Pacifica Police Department case, so you guys would understand. So I think that like language like guy, you know, pro per humiliates judge or humiliates whatever, that's not the right language you should be using. What you should be using is man who's had his life completely turned upside down is doing everything he can to redeem the reputation of his woman. And he may even feel partially responsible, because ultimately it was, in his mind, Stacy Ruprecht, the law professor in Arizona, who set off a chain of events that made that happen. And so naturally, he is going to war to try and save the reputation of his woman. And so I think the judge recognizes that. Give me a bunch of ones if you guys at least understand what I'm trying to say. I mean, it's easy to say all lawyers are a-holes and, you know, Eli doesn't know what he's talking about, but I'm trying to put a human face on this so you understand the emotions and how much deeper this goes than just like humiliating someone. I mean, this is really, really serious stuff. We're talking about people's lives.
Wasn't, even if it was, it's when she said don't contact her again, I never contacted her again. that's when the note saying, hey, this call is harassment. The next call would be a call of a series of acts, not the one before that where you tell me call you again, and then when I call you again, you say this is harassment. You can't
Can I
retroactively
stop
apply
you for a
that.
second?
Yeah.
You got the call on September 12th.
Yep.
Well, first you had something 2 years ago. It was just,
That's irrelevant.
So Grateful, I see your comment. So Grateful Dab says he sleeps fine. He wins federal lawsuits regularly. He's got money, I bet. Well, let me tell you something, brother. If you're doing federal civil rights lawsuits, the largest component of that lawsuit is attorney's fees. And since he's not a lawyer, he will not be able to collect attorney's fees. So, in fact, most civil rights cases I've done, the damages are so low in federal cases, like the money damages that you can collect, they're almost meaningless when you look at the amount you have to spend for expert witness fees and other costs. So I would have to take exception, Grateful. I think that if he's doing this pro se in federal court, he's probably not making a killing. He's just probably one of these guys who's like a freedom fighter. And he's doing this because it's what his heart calls him to do. I don't think this is like a money-making thing for this guy. I know people like this. I'm one of those people. That's how I started out. He's doing exactly what he's doing, going into court pro per. I can feel it, I can feel the connection there. So don't just assume that this guy's making a lot of money because he wins federal lawsuits. If you don't have an attorney representing you, there's no attorney's fees. And even if you do, the attorney's usually the one who gets all the attorney's fees. So don't think that federal civil rights cases are a lucrative thing. They're not. And you have to spend so much money typically to prove your case with experts that they're not. In fact, that's one of the reasons why I do car accidents and motorcycle accident cases, because I work on a straight contingency and I don't get anything unless you get something. And I'll get like a third and you get the rest, and we'll work out a deal usually on the costs, or I'll try to get them reduced. But for me, I feel like I can walk away from that not feeling guilty, at least. So just think about that too. There are some people out there who have ethical considerations beyond what legal ethics are. And and because my wife has 30 years now is a legal secretary in personal injury law. And I know I've got that kind of fire support. It just makes sense that that's what we would do. But let's keep on watching, and I'll try to get through a little bit more, and we'll probably do a part 2 because I know you guys are probably starting to fall off. And I also promised, Mr. 5 ID refusal, I would cover some of his video, and I also promised BZ that I would cover his TAP security product video. So give me a couple more minutes on this, and we'll timestamp it, and we'll come back probably Tuesday night to finish this one. And maybe I can get, maybe I don't want him to come on, but Lane might want to come on. Maybe I don't want him to come on until his case is resolved, right? Because we don't want him to potentially prejudice himself. But maybe I can talk to him. Maybe one of you guys knows him. Who knows? Maybe I can find out a little bit more about the case. But let's just keep watching a little bit longer, and then we'll get into a couple more videos and we'll call it a night. All right, guys? So probably, we'll watch this for 5 more minutes. We'll run maybe 20 minutes of Mr. ID refusal, because I promised him I'd cover his new video tonight. And then I'll cover BZ and we'll call it a night. Cool, guys? Give me a bunch of 1s. Give me a bunch of 2s if you want to go all night, which I can't do.
Well, I get what you're saying. All right. The call on September 12th.
You yourself brought it up. It's just as a point of reference.
No, it was in the call.
Yeah, as a point of reference.
She asked how I got hurt.
Yeah.
I
Right on,
referenced
Claire.
that I'm the guy that I spoke to
Okay.
2 years ago about.
So you got things to do.
Right.
Let me get to this one. So September 12th, you have this call. We have the text.
About access to justice.
You got it. On
Legitimate.
September 4th, you call again.
No,
because-
October 4th.
I saw it. Oh, just my bad. October 4th, you believe something has happened.
Outside of court, or outside of this situation.
You believe
Right.
something has happened.
Right.
You call her to address that.
Yes. One time.
Then when do you send the,
As soon as she hung up on me.
so legally?
Yeah. Like she hung up on me and I sent her the statute saying, because you notice at the end of the call, I said, you're a public employee. And I sent her the statute that,
I just wanted to.
the electronic harassment statute.
Okay. I got the time frame.
Okay. So there's the calls that she paraphrased as harassment when they're legitimate purposes. So now do I get to make my legal arguments?
Well, no,
Okay.
because she gets to come back. You
About-
don't with the testimony?
She gets to attack my evidence.
Yeah, well, she
Okay.
gets to. Ms. Butler.
Your Honor, given that Mr. Meyers just testified that he had never mentioned anything about his wife being fired from federal court until he tried to verify that information with me on October 4th, I would move to admit his October 2nd YouTube video in which he accuses me of having his wife fired.
Irrelevant, not true. She doesn't have that. That's outside. She should have put this, she should have put that on the petition before she filed it.
Hey,
I agree.
hey, stop for a second.
Let the
You know,
judge
I try to
talk.
think sometimes.
All right.
Doesn't help to have you yelling at me when I'm thinking.
She could have put it on
Doesn't
here.
help to have you
She
yelling.
could have put it on
That-
here
that-
if she had time. Why didn't she put
Hey.
through this?
Would you just,
The second is before the
let me
seventh.
think, sir. Oh, I appreciate your gesture.
Your Honor, it's relevant to Mr. Meyers' testimony today.
So what's the relevance?
He just testified that he called me on October 4th for a legitimate purpose, which was to verify whether I had anything to do with his wife being fired from federal court. And he testified that that was legitimate because he was verifying prior to making any public statements about that. When in fact, on October 2nd, he posted to his 9,000 YouTube viewers
What evidence?
a
Only
video
6,000 at the time.
in which he
She helped me get
accuses
the
me
next
of having his
3,000
wife
with
fired.
this.
Would you not interrupt her, please?
What evidence does she have?
It
What
doesn't
evidence
help.
It's growing. Hey, I bet you I got 10,000 by the end of this hearing.
Okay, that's wonderful. Go ahead. So what's the,
It's relevant to legitimate purpose for the.
What
October
evidence
4th
does
call.
she
I don't
have?
need a legitimate purpose, sir. I was saying that she
yeah,
said,
okay, I'm
she
sorry.
said that,
Sir, I
she,
asked you not to interrupt. I'm gonna let you talk,
okay.
but you keep on interrupting me.
She
Hey,
testified
hey,
that
why
I
you
called her about
Why
that.
are you interrupting me again? I'm asking for her position. and I
Wait,
want-
but her positions are not legally cognizable.
Well, let's act as this, I mean, I disagree at this moment. It's my determination. You're quick to make your own. Go ahead.
Your Honor, I'd move to strike the comment that my arguments before the court are not legally cognizable. It's offensive and untrue.
Yeah. So what's the relevance?
One of the elements of harassment is whether he has a legitimate purpose for his contacts. And he just testified that he did have a legitimate purpose on October 4th because he is some sort of journalist who goes to verify facts before he posts them in the public media. And he actually posted on October 2nd, before attempting to verify with me, he posted a video in which he accuses me of having his
What
wife
evidence
fired.
does she have
I would like
before
to
the
admit
court?
that video into evidence because it undermines the legitimacy of his October 4th call to me.
It does not, because the IRS statute for electronic harassment, she's a state employee. The reason I said it a legitimate purpose, I made it very clear. on
Well,
the
the
record.
IRS statute would have no relevance. What would be relevant is basically what she's saying. But the problem is she had the opportunity to argue this in her briefs. So let's see what the judge has to say. So Lane's not doing himself any favors by continually interrupting. I'm just being real with you. He can write everything down on a notepad and then address each point by point when it's his turn to speak. Again, I think the judge is relying heavily on the Balistreri case because he recognizes that Lane doesn't understand technical and procedural requirements. But let's keep listening.
Record, all this is being recorded and will be typed out for the appeal. I said, whether she was a public employee or not, that call would be a legitimate purpose. Any call to this woman is a legitimate purpose during business hours on her business line regarding her business functions at the University of Arizona. She's a state employee. The subsection for electronic harassment, which a social media post, which is section ARS 132916, use of an electronic communication to terrify. This section does not apply to constitutionally protected speech or activity or to any activity authorized by law. And the case law is very settled in LaFaro versus Cahill, third-party contacts. Her seeing my YouTube video does not represent a contact to her. It's a third-party thing. If she doesn't like what I'm saying in my YouTube video, don't watch.
Okay. You did post a YouTube video.
I plead the fifth.
Good answer.
Irrelevant.
Good answer.
Fifth is not having.
Of course it is. It's irrelevant. I'm not going to bring things outside the scope of this petition into this hearing like she is. You
Good
don't have
answer.
am I detained? Am I under arrest? Am I under investigation? No. She doesn't get to question things that are not on this petition, and you don't get to ask me about YouTube videos that are not contained in this
That
petition.
was a great
If they're
answer.
not in this petition, and she had it.
I can
Interrupting you,
I
you
can
asked me a question.
I did, and you kept on. I will accept your testimony that you posted a YouTube video. I'm not need to look at the YouTube video.
Of course you need to look at it if you're gonna,
You want me to look at it?
you're not allowed.
Well, you just told me I have to.
Is she introducing it as evidence?
I'm going to do that, the fact she did it.
Then provide me a copy of it right now.
Good answer.
You can't introduce so many evidence that I don't have a copy. You see how when she wanted to put the thing in, they had to
It's just the
stamp
fact,
me.
don't tell me what I can do in my court.
You
That's
can't admit
reversible
evidence
error.
on
I'm
hearsay.
admitting her testimony, that the fact the YouTube video exists.
You just said you're admitting the YouTube video.
No, I didn't say that.
Oh, okay, that's why I was telling you to, okay, so you're saying you're admitting testimony about her referring to a YouTube video.
Yes,
Good
But
answer.
you're not allowing the YouTube
No.
video, right?
I accept them, and it's about,
Can you accept that she's stating that that video that she's referring to allegedly took place on October 2nd and her petition was filed on October 7th and she included an
no,
incident
we've already been to that.
from October 4th? So why didn't she put it on
Okay,
here?
we got-
Bingo.
She could have put that on here. Why is she waiting till now?
No, man, I'm telling you guys, right, dude, Lane, whatever this judge does from this point, the way you're arguing, I believe that if you were in California, I have to always couch that you have a case for reversible error. If the judge considers that video, basically what you're showing is that she had the opportunity to include that in her opposition brief and she didn't. I mean, dude, you are, despite all the mistakes that you're making, my God, man, like if I could be Scotty from Star Trek, I think you're doing a great job, brother. I mean, honestly, I'm blown away. I'm willing to look at this, from a different perspective. That Fifth Amendment thing was insane. That was like off the hook. I wouldn't have been able to do that. I mean, if you want to become a lawyer without law school and get a California bar card, reach out to me because I've tried to train several different people and they've all dropped out of the program. Dude, I mean, you're blowing my mind right now. Based on everything you're saying, if this was in California, I think that the Court of Appeal would blow out any attempt by the court to allow that video into evidence.
Bring it up when it was.
All right. You're actually already won that point.
I know. And that's why it's better to be quiet when you're winning. I get it.
I just want to clarify that.
No, you already won that one. Oh my gosh.
State, but both of those calls were recorded and posted on YouTube.
Wow.
With my
Good
permission.
job, Lane.
To the extent that Mr. Myers is somehow arguing that my demeanor at the start of the
Wow.
September 12th
Wow.
call doesn't seem to reflect a level of
Wow.
alarm, annoyance, or harassment. I am trained as part of my job to remain calm when dealing with self-represented litigants who are often agitated by the legal system. The
Mr.
call,
Myers, come on.
the call
Holy
became,
crap.
in my,
You're all
That
members-
was
you're all
insane.
members of the bar,
All right, you told me.
the Bar Association.
That's wonderful.
This is an embarrassment to lawyers across the
Okay,
country.
I will strike that.
No comment.
What?
You're letting this lady grovel on with nonsense.
All right, I'm going to strike that. You want to go ahead, Fish.
what I consider to be the most concerning, alarming, annoying, or harassing part of that September 12th call comes
Wow.
at the end. And I don't think I actually respond after he makes his comment at the end, something to the effect of, and I'm paraphrasing because I did not record the call, something to the effect of one of two things is going to happen. Either you're
Play
going
it.
to help me
Just
or I'm
let-
going to
I've heard, I've got it.
expose the hypocrisy. I do think that comment is threatening. I think it is trying to incite me to take some sort of action and threatening me with a consequence or threatening perhaps the larger judiciary or legal system with a consequence if I don't help him.
Hearsay.
With respect to the
So-
phone call on October 4th, I just want to point out that
So, again, that's not hearsay, but it's not relevant and it lacks foundation. Okay, so my objection would be objection lacks foundation, objection relevance, objection argumentative, right? That would be so honestly, guys, I mean, a guy like Lane, based on his processing speed, I think he could easily, as well as Chili, to be honest, could easily surpass me as a lawyer and a litigator. But the one thing that I've got going for me is that I was able to extern for an appellate judge and work under lawyers when I was studying to become a lawyer. And I was able to sort of become a squire under the knights of their profession, but with my Marine Corps mentality. You know what I'm saying? A guy like Lane, I think the guy could be a superstar if he actually became an attorney, based on everything I'm hearing. And I think that she's reaching. I think she's reaching heavy. So right now, guys, we are at 5711. I'm going to mark this on my, Your Honor, I'm going to mark this on is 5711 on my chart, and we'll come back probably like Tuesday night for part 2. And hopefully I'll have an opportunity. My phone's been blowing up with people telling me to like call this guy. But Lane, I can't call you, dude. I'm a lawyer. I don't want to be accused of soliciting or something like that. If you want to reach out to me, the people who are trying to put me in contact with you, you have my permission, guys, to give him my number. I'd love to talk to the guy. I feel for him. And I think that colloquy right now, that last 5 to 6 minutes, proved to me that this dude is above average, and he just needs a little bit of, polishing, and there's nothing wrong with that. But if you hate me, Lane, I mean, I don't want you to call me and give me an earful, brother, because I'm not that guy. You know what I mean? Honestly, I wouldn't be doing this video if I didn't think that there was something there. So I'm going to go ahead and with respect to this video, I'm going to call it a night, but don't go anywhere, guys, because I promised Mr. 5 ID Refusal that I would cover his video that he just did. Let me see here, 12 hours ago. So let's get into some good old cop watching, and let's learn about consensual encounters. If you guys don't know what a consensual encounter is, let's look at how the government will try to initiate an encounter so they can initiate an investigation, put you in torture cuffs, throw you in the dungeon, and take away your money. All right. And then, guys, give me a bunch of ones for Lane. I admit, when BZ Watchdog and Brick Jonesy told me about him last night, I was suspicious. They were like, oh, no, he killed it. He was able to get the court to, force the court to let him record. And, and that makes sense because they're not trained lawyers. But in a way, they're kind of right. In a way, they were a little off because, this guy actually went and got prior permission. I didn't even want to wire whatever. It's one of these guys, right? Like my dad would have done to me, right? But I actually took the time. Thank you, Brick and BZ, for holding my feet to the fire and sending me the video. What I learned is that the guy procedurally, despite Balistreri, I think procedurally and substantively, other than his constant outbursts and interruptions, not allowing the proper colloquy, that everything else that he did was superior. I think the guy killed it. And I honestly do. And I think that the judge, to be honest with you, I really think that the judge was a good judge. I really do. And I think that the judge is siding with him. And I think that, sometimes you listen to guys like me, Lane. Listen, I'm telling you, I think the judge recognizes that she is way over her head on this case, way over her head. So with that being said, I think that he got away life under with his outbursts and lack of proper courtroom decorum. Yes, because he's pro se. But I think the main reason he got away with it is because he got a judge who's actually following not just the letter, but the spirit of the law and the spirit of the republic. I think that judge understands that this man feels like this woman wronged his wife and got his wife fired, and he's given this guy his day in court. That's just my personal gut instinct. And I believe that there are some judges out there who especially like in a pro Second Amendment state, like Arizona, who probably, pro natural law state, who are going to give a guy like me before I was a lawyer or a guy like Lane his day in court. So I really do believe that. But let's go ahead and take a look at this next video. This is going to be my homie over at Mr. 5 ID Refusal. And I have his permission to play this. And I've been following his channel because I think he does a terrific job at editing. And I always ask him, hey, man, can I roll your video? So Mr. 5 ID, if you're here with me tonight, thank you so much for this amazing production that you do in your video editing. You're amazing. And I want to share this with my audience for at least some of it. And it's an hour long. So we're not going to go that long because I'm exhausted. But I'll keep showing your stuff, brother. And maybe we can even have you on sometime as a guest to talk about how the hell is it that you are such a good producer?
I still have to do that one
Gentlemen.
for the computer stuff. We'll see.
Excuse me, gentlemen. Trying to have a conversation with you, and to be the correct, polite person would be to talk back to me.
It's going to be
Yep, still here.
probably.
You guys can please just say hello.
On October 19th, 2019, in Westminster, Colorado, Johnny ignored the female officer. In my opinion, that's the greatest insult in the world, and it's also an effective way to handle conversations with the police compared to staying silent. For more details, check the links in the description. If you agree that the police actions were wrong, leave the number 5 in the comments.
So
he's going to park on the wrong side of the road.
Westminster has shown up. He had parking over here. He could have been right here
I
on
know.
top of us.
It could have.
Mm-hmm. So
Hello, gentlemen.
So we've got some other sites that we can do as well. So
yeah, we need to do some footage over there at Adams County headquarters anyway. Sometime.
I think we're going to be staying here next day.
Could be.
So
Hi,
I
guys.
think Saturday.
You're not going to talk to me or anything?
I think Saturday is when we're really taking off.
242 in contact with 2 males just outside the North Gate break.
How many push-ups do you think she could do? Do you think that if those two guys attacked her, she would even last 3 seconds? Is this somebody you would want in charge of your community? Give me a bunch of ones if you think that she could even have a chance against even a skinny little 160-pound male. Give me a bunch of 2s if you think she's more than capable of fending off a male attacker.
No. So that'll give us the next day.
Security's not on scene, and the 2 males are purposely ignoring
Are
me.
you going to court on Friday?
Can you have security?
I still have to do that one
Gentlemen.
for the computer stuff. We'll see.
Excuse me, gentlemen. Trying to have a conversation with you, and to be the correct, polite person would be to talk back to me.
It's going to.
Clearly, there was no reasonable reason for the female officer to force Johnny to respond, even though she was very insistent in trying to pressure him. In fact, engaging with this female officer was completely unnecessary. Johnny had no obligation to participate, especially after she made a statement that could potentially make her regret it.
Trying to have a conversation with you, and to be the correct, polite person would be to talk back to me.
It's going to be.
Actually, it would be the dumbest thing in the world to talk to her. We are not obligated to.
That's right.
She did say to talk back to her. She will regret that statement.
All right, we got a second unit. Well, if we have an extra day, it'll be cool. You should probably spin that around too. So.
Yep, still here.
Probably.
You guys can please just say hello. Like I said, it's
But
a polite thing
How
to
far is that from
do.
here?
Trying to talk to you, trying to just ask
20 minutes.
what's going on, how your day is, but you don't even want to answer any of my
20
questions.
minutes to 25 minutes.
Gentlemen, how are
Can
you?
you please answer my questions and just say hello back? That's all I'm
Northwest.
asking.
So I say that we do it on Thursday. Well, I think we're gonna need to do it in separate parts.
4 cops
Well,
so far.
Listen, it would make a lot more sense in one as far as
So far, about
time.
$8,000 it's costing
But
for
I'm
this.
not,
Does it take longer than anything else?
Community resources.
I mean, longer than.
not really.
What brings you guys
Not
out
really.
here today?
No, because if everything cooks, because it's about an hour per pound.
Okay,
So
that's for the meat, so.
yeah. Well, but the point being is we need to figure out what the cook time's going to be on
So what brings you guys out here?
potatoes versus the carrots, because I'm sure that they're on different
Different time.
different times.
Yeah.
You know.
You guys don't want to
So,
talk? You guys don't talk, you just film?
but I think what else do we want to put in there?
Well, carrots, of course, right? You
Or
like.
do we want to put like celery in there too, or because it comes with its own seasoning
It does.
too,
It does.
which adds a little bit of a punch.
Yeah.
So which is nice. So
I'll get some green beer too. I know you
Yeah.
already did, but.
yeah, sir, don't touch my camera, sir.
Oh, did I touch it? I'm sorry.
Yeah, you're touching my camera.
Oh,
Okay.
oh, you do. I
So
didn't know if you
It's called a battery.
I get some green beer too.
It's a battery.
I know you.
Yeah. Yeah. Sir, don't touch my camera, sir.
Prior restraint.
Oh, did I touch it? I'm sorry. Yeah, you're touching my camera.
Prior
Okay.
restraint on speed.
I'll get some green beer too. I know you won't drink it, but.
Yeah. Sir, don't touch my camera, sir. Oh, did I touch it? I'm sorry. Yeah, you touched. Listen again. This jerk off has to make contact with me.
Drink it, but.
Yeah. Sir, don't touch my camera, sir. Oh, did I touch it? I'm sorry. Yeah, you touched. What brings you guys out here? So the question is whether when we want to, sir, you want to back up? You want to give me 6 feet? I'm not touching. Seriously, you want to give me 6 feet? Give me 6 feet, car. I have a car.
It's at this point I realize this officer has mental problems.
Give me 6 feet. I don't give a shit. Move back. Car.
Can I
Move
ask what
back.
you're doing here today?
Move back. There you go. Good servant. Good servant.
Can I ask what you're doing
Good
out here?
servant. What else do we want to serve with? So it's just the vegetables that we're going to put in there with it? Is that the totality of the, are we going to have bread? Are we going to have?
Well, it's actually a battery. So I've got a comment here from, hold on. So Chad says that it's an assault technically. Well, an assault would be well, there's criminal and civil, but typically an assault would be like the apprehension of an impending battery, right? But in this case, because the officer literally made contact with his camera, that is a battery criminally and civilly. You can be sued for that, number one, at least under general law. I don't know what the law is specifically in Colorado. They may have a different definition. So Chad, you may be right in Colorado. I'm not 1000% sure, but there are also First Amendment issues. These guys are involved in a First Amendment protected activity. They're filming. And these officers are trying to engage a consensual encounter so they can conduct an investigation, so they can gather evidence, so they can make an arrest, because their job is to raise revenue for the city or the county. That's their job, is to raise revenue. That's what police do. They raise revenue. Hopefully you guys are starting to understand this. So what these guys are doing is simply saying, we're not going to have our rights violated. We're not going to engage in a consensual encounter. Because like in California, before these new Supreme Court justices that we recently were blessed with, you could not get a concealed carry permit if you engaged in even a police contact would be enough for the sheriff to deny you a CCW. So things have changed, guys. But Colorado, it's a far left Marxist state. That could be enough right there to deny them the ability to get a CCW, assuming we get a couple more Ketanji Browns who can't distinguish the difference between a woman or a man. That might be all it takes, is one or two more justices and no more CCW for you, right? Like the soup Nazi. Let's keep on watching.
I know, but are we gonna have bread? Are we gonna have, okay, what kind of bread? We're gonna get French bread? We got French bread in the freezer.
Okay, wait a minute. Now, did you say highway patrol? Aren't they just traffic? Or no?
No, they're like the state police, but they, but apparently in a de facto situation like this, when there's not enough mall cops,
okay,
they'll call CHP because they cover everything they have a jurisdiction over everything within the state.
Do everything half-assed backwards in California.
Absolutely. Well, and I guarantee you, both of these guys are making $2.25 a year at least of our money.
Thanks, Life Under.
What's your name, ma'am?
Oh, hi.
What's your name? What's your name?
My name's Dr. Elliott.
Elliot. What's a badge or serial number or ID number?
21671.
Great, thanks. So we'll look up her salary on Transparent California. Give me 6 feet. Give me 6 feet, Elliot. Elliot, give me 6 feet.
This strange behavior made me think that both CHP officers might not be completely stable.
6 feet.
Sorry. You are making people feel very uncomfortable. People have their private patient information, and I am getting some complaints.
What we need to do is
from the supervisor saying you're making
we need to get some teddy bears.
patients
We need to get some teddy bears for the TIs.
Workers
right?
very uncomfortable.
No, absolutely.
So,
pacifiers.
That's what you
and
guys
teddy
are doing
bears.
here. Please explain to me if
Pacifiers.
that's not what you guys are doing
Pacifiers and teddy bears.
On March 18th, 2021, near the University of Southern California in downtown Los Angeles, Johnny and Denise Lynn were filming in a public area when two CHP officers approached them for questioning. Johnny ignored them, while one officer acted unprofessionally, making himself look foolish. His partner wasn't much better. Johnny later revealed that the two officers earned $22,000 a year, which was a huge surprise. This situation raises questions about their competence and highlights serious issues within the current police system. Leave a 5 in the
By the way, make sure to hit that like and subscribe button. Hit that like and subscribe button. As you guys know, I don't get as many likes as I need. But one of the ways you can help make up for it is to save. Press the save button. I try to do shows that are like 2 and 3 hours, and it's a major, major tax on my family. I'm doing this for you. So make sure to always save it to your favorites for later viewing. That's a major boost for the search engines and the algorithm. Do whatever you can to support my channel, guys, even if it's not money. Really quick, let me try to find my book. Meine Buch. And by the way, Life Under, I know I owe you a Buch. Eine Buch in Deutsch. But I have a digital version of this book. And this is a great way to support my channel because you can learn a lot about me and how to become a lawyer with no law degree or undergrad. I talk about my journey to becoming a practicing lawyer with no law degree or undergrad in Meine Buch. Meine Buch. And it's a digital version that I sell. I sell a digital version of this Buch on, and it's a Google Doc Buch. So that means it's a living Buch. And that means that as I make changes and edits, you'll get them in real time on your copy. So it's $19.99. You go, and Life Under is really helping me promote my channel. I owe you big time, Life Under. I should probably start splitting my profits with you. So maybe you'll get like $20 a month. But honestly, guys, it really helps support the channel. And I'm trying to teach my daughter how to become an entrepreneur. So anything that you can do to show her, like the transactional thing, like, okay, so I did a show and now people liked it and they wanted to buy a copy of my book, see what's going on. Like, so when you become a lawyer, you can talk about your life experiences and put them in a book and share that with them. That way you don't have to work for the state or the government, right? Or get a job as a public employee, and you can be free. You're free and independent. That's what I'm trying to teach my kids. And by the way, guys, Life Under, and I don't know if it's as a result of my relationship with Brett Pike, is now homeschooling his daughter, who I believe he said is 11. It's public. So I'm not sharing any confidential information. Brett Pike is my friend who does Cubs to Bears, classical learner. And he has a patriotic homeschooling program. He is a homesteader. And so he farms and provides for his family. And he's a former teacher, and now he teaches homeschooling. And he has a complete curriculum that talks about natural law, our founding fathers. I've had him on as a guest multiple times. Super, super cool guy. We did a Thanksgiving special. So my paid members, if you want to watch that, it was like 4 hours. We did a Thanksgiving special. It's only for my paid members, where you can watch and you can learn about the history of Thanksgiving, the Pilgrims, their relationship with the Native Americans. Hell yeah. Thanks, Nikolai. Nikolai just became a paid member. Nikolai, now you can go and you can watch that video. And anyways, as a result of, I want you guys to learn about creating parallel systems. Okay. I'm going to add BZ Watchdog self-defense company to the michaeleline.com website. But I want all of you guys who have businesses who support my channel to send me information about your business. And I'm going to add them to the michaeleline.com website to the parallel systems page. It's going to be called the parallel systems page. And so all of like Martin Luther King, when people boycotted his people, right? The shops, when they mistreated blacks, he boycotted all their shops, and they were forced to do business because they lost so much revenue. And I want to do the same thing. I want you to stop shopping at Target and all these Marxist, communist, garbage, BlackRock organizations and start buying from each other directly. Don't do the Amazon thing. Don't support anything that tells boys that they're girls or girls that they're boys, or thinks that it's okay for a man to compete in women's sports. Start fighting against it, guys. Form parallel systems where we support one another. That's what we're supposed to do. That's what God calls us to do. We look after our brothers and sisters. That's what we do. So I'm inviting all of you guys to do that. And so if anybody of you has any businesses that you want to support on my michaeleline.com website, my blog, my personal blog, where I talk about things that I like panzers and tanks and the law and all that stuff. You can check that out. But more than anything, I want to use my blog to support people who support natural law and families and homeschooling. And Brett Pike is one of those guys. And as a result of my relationship with Brett Pike, it appears, I'm not 100% sure, but it appears that Life Under the Microscope is now homeschooling his kid because of my relationship with Brett Pike. So for me, I just want to tell you guys, all the money in the world can't make up for the feeling of joy that gives me, that we saved his child from the academic industrial complex, the blue-haired mafia that wants to brainwash children to hate their country. And by the way, give me a bunch of ones if you believe, like I do, that the mainstream media is the enemy of the American people. We need to form our own system of information where we help each other learn what's really going on outside of what the government, CIA, academic, communist-run news media is trying to brainwash us into believing. Give me a bunch of ones. Let's get rid of Operation Mockingbird once and for all. Go Team MPE. Go Team DLZ. Now, let's get back into this video, and we'll go ahead and I'll share, after we do this video, a couple more minutes of this video about April Elliott and how these cops are only making 22 grand, which doesn't make any sense. We'll share BZ Watchdog's promotional video. I'm trying to help support his self-defense company because the frauditors are doing everything they can to put him out of business. So I'm not going to get into it, but he's losing income because of what he's doing on YouTube. And so anyway, we can support his business for the holidays, buy self-defense products, self-defense foam. We'll get into that video in 1 minute. But let's go ahead and finish up the last part of this video, and then we'll get into BZ and we'll call it a night, guys.
In the comments if you think the actions of the police were inappropriate.
Hey, I work for a news media group. I'll be doing some coverage on the upkeep of the service cars out in the parking lot. Just want to come let y'all know that I'll be out there.
Michelle?
Hello, how you doing? Hey, I work for a news media group. I'm self-employed. I'll be doing a cover story about the upkeep of the service cars out in the parking lot, the marked and unmarked cars. So I'll be in and out of both parking lots. Just want to come let y'all know that I'll be out there. Thank you. I'd rather not give it. I'm sorry.
Okay. Well, I mean, if you're not going to give us a name or tell us what it's for.
Well, it's just personal publication. That's all. That's all it is.
But what is it concerning? I mean, what marked versus unmarked?
We can't read your publication.
Well, once I release it, I'm sure it'd be viewable everywhere. I just haven't released the story yet, nor have I released the core of it yet. So I can't say much.
Concerning? I mean,
just public. Just that's it.
I'm Captain Groundstaff.
Nice to meet you, partner.
Good to meet you.
Like I just explained to her.
Jeremy, I think you might be right, brother. I'll go look. I'll play this video again, like on Tuesday. It may be 122,000. Jeremy might be right. I thought it said 22, and I was thinking maybe they had gotten like in trouble or something. But guys, I've been going almost 3 hours, so I'm kind of tired. So thank you, Jeremy, for calling me out on that. It's all about iron sharpening iron. If you don't catch my mistakes, I might miss them, and that might cause trouble for me. So I thank you, brother, for pointing that out to me. Let's keep going.
I've done nothing wrong. I'm just out here taking pictures, and I'll be on my way. She's asked me for my name. They've asked me for ID, and I've done nothing wrong. And the first thing you asked me was for my ID, and I've done nothing wrong.
You have warrants or anything?
Do you expect me having a warrant?
I don't know. Well, I don't understand.
So who are all of you people here? Can I have name and badge numbers?
Chief Deputy Nathan Mays.
Nathan Mays.
Go in here and sit down on top of me.
You're Andy. This is Jason. And who are you?
Smith.
Smith.
Yeah. Why are you taking pictures of our cars?
Because
you're on our property.
They're public. This is
Our
public property.
property.
These are public service vehicles.
Why are you taking pictures of them?
Because-
Some of these are undercover cars.
But they're in
so
public
you know who
view.
comes to take pictures of undercover cars? Drug dealers.
Well, that's your perception. I can't judge you for your perception. Well, sir, this is public property, and if you ask me to leave public property, that is, which is public, this is tax funded. This isn't paid for through some public. Some private
You got any
organization.
ID on you?
I do not. I haven't committed a crime, so
What's
you don't
your
need
name?
my. I don't want to give. I haven't committed a crime, and this isn't stopping ID state. You have to be able to give me reasonable, articulable suspicion of a crime, and you can't give me that. So I haven't committed a crime.
We have undercover
You
cars
need to
here
leave.
that don't need to be.
You're asked to leave this
Okay.
property now, so you need to go.
Can I ask you what your job title is here?
I'm captain.
You're captain.
Yeah.
So as captain, you don't know that you can't tell me to leave from a public
I can
space.
tell you to leave.
But this is public, and I can tell you.
Tell 'em.
But this is public property, sir.
I can tell you no.
This is public.
Need our vehicles.
Well, this isn't about what you
Video
need.
or
This is about the Constitution telling me that I have the right to my First, Second, Fourth, and Fifth
Well, if
Amendment.
you're done taking video, then you can tell us why you're taking video.
I'm gonna
and
step
pictures.
this way because I don't like this officer behind me. I'm gonna step this way. I'm not going anywhere.
Nice
I'm just gonna stand this
toothpick.
way so I can see him. That's all.
Well, I can see it.
But again,
You can tell us why you're videoing and
because the
photographing our
Constitution says I can. If you want to take that up, you go. Take that up with the four founding fathers of the country.
Okay.
The Constitution tells me I can do this, and it's unconstitutional for you to allow him to tell me that I have to leave this public space when this is public property. That is unconstitutional, and that is against your oath. That is against your oath.
Here we go. We're asking you to leave.
All I want you to do is honor your oath, sir. I'm not giving you my name. Just honor your oath. Officer, listen to me, okay? There's a gap between Americans, but there's
you to stand here and photograph our cars.
Y'all drive your cars and people can see them in public. What's the difference? If my eyes can see them, so can my camera. Y'all don't drive these cars on.
You're not going to produce ID. You're going to leave.
Sir, I don't have to leave because I'm not telling you my name. Tell me the statute that says if you don't identify yourself to a police officer, you have to leave.
In our parking lot.
But that's not a crime. That's not a felony nor misdemeanor, and you should know that. That's not a felony or a misdemeanor.
Do you have any weapons on you?
I don't. You can
mind if I check you?
Pat me down, please,
Okay.
sir. He's gonna pat me down.
I would
Go
have
ahead.
never agreed to that.
There's no weapons on me.
Had no reasonable articulable suspicion.
Don't want name. We feel
So I can see how he's terrified of those cops. Look at how many of them are. He sounds like a black man, right? First of all, he's in the South, right? He said IB, so that's like Ebonics. He should have never let them put a hand on him. And you should never go out there by yourself, dude. What are you thinking? Should always have a buddy with you at all times who's filming you while you're filming. I'm just telling you how you should be handling your business. But so far, other than letting that cop put his hands on you, I think you're doing a great job so far. Give me a bunch of ones for this brave man. I don't know if you guys know what it's like to be surrounded by a bunch of cops who are thinking of everything under the sun to try to arrest you. But that is pure bravery. That guy is Maximus. Maximus. Give me a bunch of Maximuses in the sidebar. I really got a lot of respect for that dude.
our safety, so we're gonna make sure you don't have any weapons.
That's fine, sir. Please search all you need. I have nothing on me other than my keys.
You don't have any weapons.
No, sir. You can check both legs.
I would have never
I'm
given
literally
him
just here to
permission.
take pictures and videos, but I just don't think it's
Are you
fair.
done? You've been here for a few minutes. Are you done taking your pictures
I'm not.
and videos?
I would have been done if I didn't get interrupted. But what I don't agree to is that there's some few high-ranking officers here who I respect their work from you guys, but to allow him to go against his oath and tell me that I have to leave a public space, that's unconstitutional. And there's already a gap between Americans and LEOs because of this type of stuff. And for you to allow him to tell me that he can make me leave public property, that's unconstitutional. So can you please correct this officer?
Now you're talking to me.
Well, can you please correct this officer and ask him to honor his oath when dealing with law-abiding citizens? That's all I want you to do.
What he's doing, okay, we're trying to protect our officers.
But your job is to protect
What
the
you're
public.
doing with that camera, putting that stuff wherever it's going to end up, whether it be social media or whatever.
But
is
you're a
not
public
safe for our
servant.
officers.
But you're a public
And the
servant.
DeKalb County Sheriff's
You don't put that
Department.
badge on to come make sure he's safe
Do you
every day.
understand what I'm saying?
I do, but I want you to understand what I'm saying. You just allowed this officer to try to violate my rights, and you didn't say nothing about
I
it.
sure did not.
Yes, you did. There's 5 or 6 officers out here. Listen to this man tell me that I have to leave this public space, and
Are
I
you
can't.
done?
No,
Are
I'm
you
not
done
done.
doing what
I'm
you're
not
doing
done.
today?
And if y'all are gonna follow and harass me,
We're not harassing you.
The mayor-
You come on our property, sir.
this is my property.
Let me explain something to you. No, this is county property,
Which is
not
public.
property. Which what I'm telling you is this, okay?
Let me hear.
When we run a facility here, a detention facility and everything else, it's got inmates confined in here. So when somebody's up here, they're not wanting to tell us their name or what they're doing here, we get suspicious. So what I'm telling you is that you can leave this property now, or it's county-owned property, and you're going to get charged with trespassing, okay?
Can I see the affidavit? Well,
I'm asking you to leave now, okay?
Well, catch your question.
So, no,
I'm on my
we're
way
done.
out, but
We're done.
I want to ask
Just
you a
please
question.
leave, okay?
So you're asking me to leave. So you're not telling me that
I'm
by law
asking
I
you-
have to.
I'm asking you to please leave this property, okay?
Or you want to arrest me?
I'm telling you, there's a good chance you're going to end up getting charged with trespassing if you don't leave.
But I haven't been put on trespassing here.
But you're being told now, okay? That
so
we're
I'll
'cause
leave.
You're
Under
acting
threat.
very suspicious to us because you don't want to tell us anything about.
But have I committed a
We've
crime?
got. We have got.
I'm not inside there, sir. I'm not
We've got
inside.
we have an outside.
I'm sorry. I'm talking to this officer here. Okay, but I haven't crossed not one of them gates. I am outside. When the
I'm not
people of the
saying-
public want to come in this building, where do they park?
And people
There and here.
You got your photo. You took a photo or whatever it is. That's fine. Now we're asking that you leave. Okay. We're not going to sit here and argue or anything. We're just asking you leave because we have jobs to do too.
Well, do them. I'm not telling you not to do your job.
Well,
I have a
please-
job to
just
do.
Please leave. Okay.
Are you from Marion?
Just please.
I'm gonna talk to you because he's irrational
Are
at
you
this
from
point.
Marion?
Can you please inform him that This is public. Yes, you're irrational.
He just explained to you, sir, this is county-owned property, okay?
So can you ban?
We're asking you to leave. If you don't leave, you are subject to be charged with trespassing, okay?
Can I ask what crime I've committed? That's all I want to know. How could I be trespassing when I haven't been put on trespassing here? But I haven't been put on trespassing. Where's your attorney? Can I talk? Please, who's the chief of police here?
That'd be me, bud.
That'd be you. You're the chief of police. So as the chief of police,
you want to talk to the chief of police?
yes, I do. I do.
Okay,
And then I want the mayor, because for all of you to tell me that I have to leave this publicly owned building. If I had a business here, which I'm conducting business, I would park in this parking lot here, correct? And I am in this public area of a parking lot, and he's going to tell me that I can't be here.
What business are you conducting?
So now we're getting personal with it.
For what reason?
Because it's personal. I have a personal business that I run, and the First Amendment of the Constitution tells me I have the right to free press. Now, if you're going to wage war on my constitutional rights and tell me that I can't do it, please tell me that.
What?
If you're going to wage war on my constitutional rights and tell me that I can't film,
What you're trying to start or what?
I'm not starting anything. You started this by telling me that I'll be trespassed from a publicly owned area because I'm filming.
Is it
private? Is it private? That's all I want to know. Can anybody here tell me, is this private property?
It's owned by the county.
Who pays for the county? Taxpayers. How can you tell me I can't be here?
Are you a taxpayer in this county?
Do you expect me or not to be? But this is still public. That's like telling me.
You live in this county?
I'm talking to this officer. Yes, ma'am. No, ma'am, I wouldn't because I.
So go pay your taxes in South Carolina.
So now you're telling me that I can't be here, ma'am. I'm talking to this young man here. Please don't act like that. Please don't act like that, please. Because y'all are telling me that this is county property. Taxpayers pay for this.
You gotta love Southerners. Even their cop watchers are just so genteel. I gotta tell you, man, I'm impressed by this guy.
Means that y'all have no authority to make law-abiding people leave here. You can't. But because I've been threatened with the arrest and trespassing, I'm going to leave. Officer, I'm leaving. I don't want to ask any more questions. No, I'm leaving because this officer here is going to tell. Bro, listen, if you're scared for your job, get a different job, brother. If you're scared, if you're that big of a sissy, get a different job, brother. Get a different job.
You're making it personal.
No. He's made it personal. I'm done talking to you. I'm done talking to you, brother. No, it's not. It's not. I won't. I'll do it on my time, okay? I'll do it on my time. But thank you for making yourself like an idiot on the internet.
Now you're making it personal.
It's not personal.
Don't call my chief deputy an idiot. You understand?
No, I say he made himself look like one. I have the right to free speech. I have the right to free speech.
You ain't going to come on this property and disrespect.
But they can disrespect me, though.
I never heard him disrespect you.
By telling me that I can't be here,
sir, once again.
But I'm listening. And again, thank you for being professional because you're the only one that I can have a dialogue with. And I respect that. But what I don't respect is this officer telling me and intimidating me, telling me that I can't be here just because I make them suspicious. That's not a felony or misdemeanor, officer.
Have you ever worked in law enforcement?
I have law enforcement attorneys all through my family.
Let me come.
Yes, sir.
Okay. Go ahead. This is a law enforcement center. You understand that?
I do.
We have narcotics officers. We have detectives. We have vehicles here that don't need to be seen by ordinary public. You understand that?
So,
okay, that's a threat to their safety.
Now,
that's a threat to their safety.
I understand that.
You do understand
now,
that? Do you agree with me that their video on social media is a threat to their safety? Do you agree with
Can I ask you a question?
Answer my question.
I do, but I don't at the same time, because if it can be seen from public, I can film more photographic per the Constitution. If it's in public view, I can be seen. They don't hide these parking lots and garages that I went into to film this. This is in plain view right here. I'm having a awesome dialogue. You stay right there, please. I'm talking to him. As me, you both can agree to that this is in public view. I didn't go behind this building here. I didn't go behind the fence. I didn't do any of that to see anything I saw. This is all in public. I can see this car here. And I can see that car there from the road.
Okay.
So
we're gone. Okay.
So, but do you get what I'm saying though? It can be seen from public view. I can see that car from the road there. Okay. So that's like telling people when you drive by here, please don't look at our parking lot. That's bogus.
We're asking you to leave.
Trying to start
whatever. No more photographs of the vehicles, please. You've got all you need, okay?
Actually, I don't, because y'all interrupted me. I actually have 2 more cars I got to do, and then I'll be gone. I have 2 more vehicles, and I'll be gone.
We're asking you to leave now. Okay?
You know what? For the fear of my safety, I will leave. But I want y'all to know that y'all have to be informed on public photography because this is unacceptable. Okay. This is completely unacceptable. And to back up your chief, to act like a complete. Oh yeah, please do, because you're going to hear from mine.
All right, sounds good.
And you're who again?
Captain Grindstaff.
Captain Grindstaff. I had no problem with him. I want to ask for his name. Okay. And the name of your chief of police is?
Chief Deputy Nathan Mace.
Chief Deputy Nathan Mace.
Yep.
Thank you.
Evening.
Thank you. Y'all have made this is ridiculous here.
On April 3rd, 2019, in McDowell County, North Carolina, Auditor News. Now, South Carolina was inspecting the public parking lot of the sheriff's office. A confrontation quickly erupted when staff objected to his presence and called officers for intervention. Despite not violating any laws, the auditor was pressured to leave by the captain and deputies simply for filming the parking lot. The situation became tense as the captain grew frustrated and the sheriff intervened irrationally, stopping the exchange. The auditor remained calm, explaining that if the vehicle was undercover, it should have been parked in a private area and
Bingo.
demanded accountability from the officers. This incident highlighted the lack of legal understanding within the police force and the importance of protecting individual freedoms.
Leaving our building.
So
You have no right.
So guys, I'm gonna stop this one at 1957, and that is Mr. 5 ID refusal. So we're gonna go ahead and we're gonna roll that again next week, or like maybe Tuesday, right? But I want to drop this for you in the sidebar because I really think Mr. 5 ID refusal has an amazing channel. I'm asking y'all to please go to Mr. 5 ID refusal and like and subscribe to his channel and let him know that Team MPE sent you. Because I love his production. I love his narration. I think he's super good. I put him up there with Delete Laws. That's just that he's really niche. He's all about ID refusal, where Chili's more of a government accountability activist. But I think all you guys working in tandem are all about the same thing that I'm after, which is teaching people about their fundamental, unalienable rights and making America a safe place for the citizenry and the abolition of the administrative state. Let's get rid of the bureaucracy and restore the constitutional republic. Let's make America a place where our children are no longer being brainwashed by a corrupt public education academic system. Let's homeschool our kids. Let's make sure that we homestead, we grow our own chow, our own food. We stop engaging in these horrible corporate scumbag complexes where they're trying to tell your little boys that they're girls and your little girls that they're boys, and make America safe for our kids again. Have as many babies as you can and change this country for the better. Find a good woman who understands that you're going to look after her and protect her, and make America safe again for families. Give me a bunch of ones for families. So the next thing that I want to get into is, yeah, that's right, Chad, about making America glorious again. Maybe making America more glorious than what our founders wanted. I mean, let's make this place rock and roll, man. Remember, people are trying to come here. They're trying to escape from everywhere else. Let's make it a place where people still want to escape too. Now, the next one I want to show y'all is my Marine brother, my Marine brother, BZ Watchdog. As you guys know, he's been struggling and going through some hard times right now. And he has a small company called TAPS Security Products. And we got Christmas coming up. So even if you don't need his products, hey man, if you got an extra $1,000 laying around, buy his stuff and give it to all your family member and friends. I don't give a crap. Support my friend BZ. He's a good guy. He's a fellow Marine. And you know how us Marines are. We're brothers for life. So please take care of BZ, and he'll give you some good products in return. I'm going to try to blow this up a little bit for y'all so you get a better look at it. This is his promo video. By the way, I don't get anything out of this other than just the feeling that I did something for a friend. I'm not an affiliate marketer or any of that crap. Maybe someday. But right now, I'm really just doing this because I want to make sure that we support BZ Watchdog. He's a good friend of mine. He's a fellow Marine. And us Marines, we're brothers for life. And it's our duty to look after one another. And so go ahead and check out his promotional video. And then after that, we'll call it a night. All right, guys?
Another great product brought to you by TAPS Security Products. Streetwise Security Products has manufactured another fine product brought to you by TAPS Security Products. This is the Falcon 5-inch spring-assisted Second Amendment knife. It's got a 3-inch handle with a 2-inch blade that has the Second Amendment of the Bill of Rights etched and engraved into the blade, as you can see here. It also has a seatbelt cutter along with a glass breaker at the very end of this knife, along with the beautiful American flag handle. The Second Amendment knife Retails for $19.99. Right now, you can buy it through till the end of Christmas online at tapsecurityproducts.com for a low special price of $14.95 plus tax and shipping. Again, that's tapsecurityproducts.com. Get your products and stuffing stockers now. Another great product brought to you by
Now, I don't
Tap
know
Security
about
Products. Streetwise.
I don't know about stuffing stuckers. I think what he meant to say is stocking stuffers, but I get it. Make sure to. I just dropped the video link in the chat box there, guys. But he's got some really cool stuff. He's got that spray foam, and he's selling stuff for cheap, y'all. So, like, buy it in bulk because it costs him a ton of money for shipping and handling. So look at all this stuff. I'm going to be throwing him on the michaeleline.com website as a vendor that I support on my Parallel Systems page. And again, Life Under the Microscope, man. Thank you so much for supporting my friend Brett Pike and having the foresight to get your kid on a private homeschooling program and out of this Marxist communist public school system that teaches children to hate their parents in the country. Let's restore our country back to the greatness we once had before the Department of Education brought us from number 1 to like below 100 in education in the world. Anytime you get a bunch of Marxist bureaucrats in charge of anything, all you see is the destruction of what was once good. So give me a bunch of ones if you support the Constitutional Republic, BZ Watchdog, and Team MPE. Hoorah! And yes, guys. So thank you so much. Yeah, it's like a spray foam. What's the matter? You like a spray foam pepper spray that so it doesn't the mist doesn't blow back. So it's really cool for people who believe in less lethal force. Unlike me, who I try to have at least one FNP 45 or a Glock 21 in each room of my home. Other people may want to use less lethal force than me, as opposed to my center mass, see you later, alligator system of home defense that I have. I really appreciate you guys joining the channel tonight. And then Mr. Lane, I can't call you, even though a bunch of people are shooting me with your number. But if you want to reach out and just talk to me, I'd like to find out more about what happened confidentially. Of course, I wouldn't share anything about your case unless you told me you wanted me to. And even then, I would probably not do it until your case was over, out of respect for the understanding that it could put you in potential jeopardy. But if my gut instinct is right about what's happened to you, and just based upon some of the things that you did in court, I have a lot of respect for you, man. There were a lot of mistakes made, but I think that overall you killed it. So, and you're talking to someone who's been practicing law for about 20 years, and I was a paralegal before that. And I became a lawyer without a law degree or an undergrad. So I understand how hard it is. I get it, but I really, really respect what you did. Have a lot of respect for what you did, brother. So everybody, thank you for supporting the channel. Thank you guys for all the super chats. Thank you. What's the matter? You, Life Under the Microscope, Chad, Danelle Brown, Justice for Michael Jr., Age Go, Salt Shaker, No Thanks, Life Under the Microscope, Sin City Giggles and Liberty. I'm trying to scroll as fast as I can to make sure I thank everyone for supporting the channel. Toads, MC Froggy, Lawyer Dog, as always, my libertarian friend. Thank you for supporting the channel. And then Chili DeCastro for showing up and showing some love to the channel. That's the longest I've ever seen Delete Laws ever be on one of my shows, by the way. So give me a bunch of ones for Delete Laws, Chili DeCastro for supporting the channel. Nicoley, our new member. We got our new member, Nicoley, tonight. Hopefully you're watching my Thanksgiving special that's only for members that I've saved in the back end, 4 hours that you could listen to if you're a trucker on a road ride. I'm like the new version of Rush Limbaugh with a little bit of a legal edge. And then Josephine Pisculli, thank you so much for supporting my channel. Grateful Dabs. Kevin Birnarski, thank you so much for supporting the channel. Man, there's so many. Chad, all you guys, man. Gessalig, Grateful Dabs, dude, you're the man. And Chevy, thank you again for all the amazing super chats and looking after my family to make sure this channel can keep going live. Danelle Brown, I think I already thanked you. Selwyn, of course, my friend, with your medieval sounding knight in shining armor name, right out of a novel. Juice Orange, Greg B, all you guys, man. Jeremy Height, Jeremy Height. And then we got some new ones. We got Jody Shiloh and then Claire Stillwell, who said that she sees more women on my channel than ever. Thank you, all the ladies, for showing up. You know that I'm the guy who's going to throw down my cloak so you can get across the water in the road, so you don't get your feet wet. So at least you gals appreciate that. Salt Shaker, Lonnie Buff. Man, there's so many. I'll never be able to thank all of you, but thank you all. Thank all of you for supporting my channel. We went 3 hours and 24 minutes tonight. I am exhausted. I hope I can get up tomorrow and get some work done. But make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel, right? So make sure to like and subscribe. Double tap me. Give me as many likes as you can. Come back and make some comments as well to get that algo love, right? Like after the show's over and it goes live, make comments in the comment section, because this live little comment thing doesn't show up as comments, unfortunately. Like if I had all your comments in my comment section, my videos would be #1 all over YouTube. So those comments and the likes and the subscribing really helps me a lot. But saving, more than anything, saving my videos to your favorites to view later is the #1 thing that you can do to help my channel grow. So please do so. Again, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. And with that being said, Semper Fi, do or die.